Please allow me to introduce our speakers for today. Dr. Aaron DeShaw is the founder of Trial Guides, a co-founder of Settlement Intelligence, and the founder of DeShaw Trial Lawyers. He has individually and in cooperation with other law firms obtained settlements and verdicts for his clients in excess of 1 billion. DeShaw is the author of 3 books and is featured in multiple professional education and videos on the topic of traumatic injuries and insurance. David Ball is the nation's most influential trial consultant. With his partner Artemis Malakapur, he guides plaintiffs' civil cases and criminal defense cases across the country. They have an unparalleled record in helping attorneys with every size and kind of case. Dr. Ball wrote 2 of the best-selling trial strategy books ever published, David Ball on Damages, and with Reptile co-founder Don Keenan, Reptile, along with numerous other and important published works. I'm going to go ahead and end my portion though and turn it over to them because that's really who we're all here to see.
Thanks so much, Jessica. Well, welcome, my friend David Ball. How are you doing today?
I'm doing fine, Aaron. How are you doing?
I'm doing great. So, thank you for allowing yourself to be interviewed by me. I wanted to go into some depth that a lot of your readers may not know about you, and get some of your influences and the way that you see things going in the future in regards to the practice of law. So. Many lawyers that have read your works may not know you personally, and I just wanted to get a little bit of background about you. Where did you grow up, and how did you get to, first of all, your involvement in theater, and then we can go from there.
Well, I was born in the Appalachian Mountains of New York, which are called the Catskill Mountains. Daddy was a bootlegger, and so that was one possible direction I could have gone in life. But then they went and got rid of prohibition, so suddenly, at before birth, 10 years before I was born, I was out of that job. I grew up in Stamford, Connecticut. So, city about 35 miles outside of New York, so kind of in the umbra of New York City. Went off to engineering school. What was a good boy supposed to do in those days? A doctor, a lawyer, or an engineer? I was interested in trials. I was not interested in law. Engineering, when I got to the point where I didn't want to do engineering, I hung around school for a long time. Long enough so that I finally obtained what is referred to as a Vietnam PhD, staying in school long enough to try to stave off the draft, and then went into the Peace Corps, which of course did not work to stave off the draft, but I somehow managed to stave off the draft. I lucked out.
Hmm.
And I don't, in a sense, I regret that because I don't know what I would have done had I been drafted, being very much against that. Anyway, with the university, with school, I ended up with a fairly solid background in the sciences during my time at Rensselaer, and then the arts, and then I became what everyone becomes at one point in their lives, which is an English major, at which point you're in great danger of going to law school. And I did entertain that. I have a very bad memory, and I thought that is not a good thing in that business. And suddenly I was in theater, and it's a very long and trivial story about how that happened. And I had a very lucky theater career. Really, really lucky. I went to a school, Minnesota, University of Minnesota, for a PhD in theater, and it turned out they also forced you to take a minor in something. So for lack of anything better, I just took it in small group communication without even knowing what that was. And it wasn't much of a minor. It was, 2 or 3 courses and reading a book or two, which I considered totally irrelevant. And it was, because in theater, you don't want small groups to communicate to. You want big audiences. So I thought, this is nonsense, but I did it. And, it turned out to be, along with all the engineering and science stuff, pretty much the heart of what I do these years later. The communications, the theater, the understanding audiences. My first, and well, it was pretty long, professional job was at a place called the Guthrie Theater in Minneapolis, which at the time was sort of the theater in this hemisphere. Again, total luck. I didn't deserve to get there. And one of my jobs was to watch the shows every night, or pretty close to every night, to make, because we were in repertory, to do one show one night, another show another night. So it was very easy for the acting company, as good as they were, to kind of lose the sharpness they had when we started. And my job was to go down and make sure the show is okay. And I rapidly learned the way you make sure the show is okay is by watching the audience very closely. So I sat where I could see, of the 1,400 seats in that theater, I could probably see about 1,000 faces at a distance, but I could focus and I get a very good feel for what was going on. And I think I developed a strong audience sense at that point, which has been very important to what I do now. And did a lot of theater. After I left the Guthrie, I taught and loved teaching. Hadn't taught before. Went to Carnegie Mellon, which has a really good theater conservatory program. And I was there for a number of years. Wrote a book about it,
Backwards and forwards.
backwards and forwards, yeah, which is still, the book is almost 40 years old. See how old I am. And it's still one of the best-selling theater training books out there. It's a very simple book on text analysis, which is really a book on how to tell stories, which is why I'm glad Trial Guides is selling it, because lawyers need that. And then I ended up at Duke, running the theater department, and Duke has, lo and behold, a law school, and it has some courthouses. Now, it's a long story, but I started watching trials. I thought, boy, I could really do these folks a lot of good. Not
Mm-hmm.
because I'm smarter than they are or know any law, but I know a lot more about how to deal with your lawyers are in the business of trying to make up other people's minds, which is almost exactly what theater does. We're in the business of trying to get other people, the audience, to think and feel the way we want them to. And the techniques are largely the same. And if you trace back theater and trials to their origins, the same people started both. I don't mean the same nationality of people, I mean the same human beings in Athens and Greece. Started both of them, and pretty much for the same purpose. For the purposes of swaying the community, instructing the community, persuading the community. I thought, well, there's a lot more here than just a coincidence that trials are like theater and trials are like the stage. They are the same thing with a different purpose. And that's where I got started. And then I got very interested in how the law can be framed to help us. So stop thinking of ordinary care as an average level of care. It's not. You can frame that to mean the safest available level of care is what ordinarily safe people do who are trying to prevent harm to other people. And things like that. How do I get people to do, the jurors, to do preponderance? And now with the criminal stuff, how have we crossed the bridge where now if a lawyer is using the rule out method, which was developed mainly to get jurors to apply the concept of reasonable doubt to cases, because they don't, no matter how much, now they do. And it's made an enormous difference. So anyway, that's kind of the circuitous path. The science thing from Rensselaer was extremely important because it teaches you how to think linearly and logically. And it also teaches a lot about what constitutes legitimate science. And so naturally, that's become extremely important in both the civil and criminal arena, even more today than ever. I don't remember what your question was, but I think I answered it.
Yeah, no, no, exactly. And so I'm just putting this together in my head because I remember a few things from the early days of us knowing each other. And Don Beskin, I think, was an important person sort of in getting you
Yes.
into law and I guess working with you on early concepts. And he was at Duke, right? Is that how?
Don was a practicing lawyer who at the time was teaching as an adjunct at Duke. He later became a full-time professor there. Still is all these years later. I think he's right at the point of retirement, but I'm not sure. And aside from becoming a very good friend, was an incredibly helpful force on me getting into this, and became a good sounding board. When you don't know much about the law and you're advising lawyers how to do trials, which was me 30, 35 years ago, it was very useful to be able to call up and say, ask a quick question. It could save me a lot of time. And since he didn't just practice, he taught the stuff, so he had to know it on a broader level than a trial lawyer would. Was very interesting. But he's that way with everyone. He's that kind of very special human being that we all hope we have a few. People miss the name is Don Beskind, he's in Durham, and we've been buds for a long. I'm proud to say buds for a very long time, and always keeps me in mind that there are people in this business a whole lot smarter than me, because you know.
So you get into working in law and you continue writing, and there's a number of early books that you wrote. Theater Tips and Strategies for Jury Trials, of course, and the very first version of David Ball on Damages, which I gotta say, I saw those books long before I started Trial Guides, and I compare David Ball on Damages edition one to a Hemingway book, very small for those of you that never got to see it. And I tried to find my copy, but a very small book, probably 100 pages, and every single sentence was exactly to the point. And I just,
I seem to have lost that skill along the way.
well, there's a lot more to cover now, but just a genius book, and I got introduced to you through David Ball on Damages, edition one. So, what was influential on you in creating that book? I mean, how did you get to distill all of this information down into 100 pages, I
Well,
suppose?
necessity is a great motivator. Um, I'm not good at knocking on doors and say, hire me. It's very hard for people. Excuse me. We have allergies in North Carolina. Um, I'm not very good at that. I've been writing a series of articles monthly for the North Carolina Trial Lawyers Weekly. It was sort of a different tip every month. And I decided, and I knew a lot of people were reading it. And I thought, well, if the lawyers are reading it, and the work I was getting in North Carolina was largely, I didn't know any of these people at the time. Um, why not a book? Let's just take this stuff and assemble it. I didn't end up doing that. I ended up really delving a lot deeper than you can in an article. And that's when I really did the research to go back and say, how come these two forms are so similar? Because there's a lot to be learned in that similarity about cases. So that's really the source. The impetus to do it was a marketing impetus. Um, and it happened to coincide with a period where I saw I don't want to do civil defense work. I didn't respect that side. I shouldn't even word it that way. I don't mean to be that negative. I felt that lawyers who work for insurance companies don't need the help because the insurance companies got limitless resources. They hadn't yet started pouring them into cases the way they do today. If you've got a significant case and you've done a few focus groups, count on the fact that the other side has done a dozen of them, and much more thoroughly than you can ever afford to do them, et cetera. So and as a matter of which side I preferred to help, I didn't have an axe to grind at that time against insurance companies, but I sure did against people who hurt individuals and tried to get away with it. That passion preceded my getting into this line of work. So the obvious choice. And that's why the Damages book, I knew defense people would read it, and I got myself involved in that old battle. Should we put it out there because they'll see this stuff? And then I figured that's a bogus argument, and a lot of people use it. Don't let any of those defense lawyers in it. Well, the first time you use it in trial, they have seen it. And if it's now any good, they're going to tell. That's what happened with Reptile. There was no defense version of the Reptile out there, but there really isn't one to be made up. But the defense certainly got very familiar with all of it. They just never figured out what to do about it.
Yeah.
So that's what it was for, and it rapidly became a campaign. This work for me has become a personal campaign. It's nice to make a good living at it, but it affects far more people in far more fundamental ways than I ever felt I could do with theater.
Right.
You can do that to some extent with theater, and if you're a different kind of theater artist than I was, you could probably do it with a lot more. But even then, it's not the practical thing of who's going to feed this kid, and how do we keep this person out of jail and that sort of thing.
Mm-hmm.
So it became a campaign, and that's when you say the impetus, heart marketing. And as I got into doing that book, I realized I was on a personal campaign because I had to be careful with my editing to keep from getting too hysterical. You couldn't call the other side a bunch of SOBs and be helpful. Now I can, but I don't.
Sort of coming into that, were there any influences on you in terms of things you were thinking or how you came up with those methods, or was it really just going out and studying people in your
Well, it
area?
was the theater. I mean, the primary influence was, what do we do when we want someone's attention to land here and not there?
Mm-hmm.
That's a fundamental question in both theater and in trials. And there were very few lawyers that I was running into. I was watching trials downtown all the time. And by then I had started to travel to other places to do cases. And I always took an extra day or two to hang around their courthouse and watch trials there. And that was one skill lawyers did not have. The only one out there who was even trying to teach it, and I didn't know him at the time, or had just met him perhaps, was Eric Oliver, who's not a lawyer, but a brilliant trial consultant. And the concept of how do you get the jurors to focus where you want it? It's a fundamental question. We have it on the stage. How do we get the audience to look at the person we want them to look at? There's 40 people on the stage in Phantom of the Opera at one time. How do we get them to look at the little heroine? She was over there in the corner, and we need to see her. And you can only do so much by putting one light on her and dimming the light on everybody else. But there's ways to do that. How do we get the jury to understand the important parts of the story? There's things at the beginning of, say, King Lear that are crucial to the audience understanding the plot, and virtually every English professor in the world has missed it. It is that important, and yet they've missed it because there's no director or somebody helping the English professor who's looking at it as literature. How do you get people? Well, this is the same thing in trials, especially the way the defense throws everything at you. How do you extract stuff? I recommend to people something called the red file folder, which I think is in the Theater Tips book, which takes the most complex case and goes to the single important thing you need to the jury to remember, and it shows you how to use it so the jury will accept that as the most important thing in the case without even realizing that that's what they've done. It's no different than that's where the inspirations came from for the theater stuff. And in a sense, working with theater audiences is, the longer I'm at it, the more I see they are like jurors. This is one of the reasons why we now have several really good consultants. Jesse Wilson, Joshua Carton, there are others. I hope they're not insulted if I don't mention their names, but I have a terrible memory and I haven't been close with them in the past recently. Their names are gone, but they're out there and they're good because that's their basis. We're going to exploit that in this series of webinars we're doing on trial guides in the fall to get those people so people can hear from more of them in the same place talking with each other. But that theater thing has stayed the fundamental source. the inspiration is watching good attorneys do their jobs. There's nothing more exciting to me than watching that. And there are many more of them today than there were back when I got started. Many,
Yeah.
many more.
Yeah. Well, I mean, it's interesting because during that period of time, there was very little really for the plaintiff's bar. I mean, Mo Levine had written these books back in the 70s.
Yeah.
Eventually, we repackaged it, trial guides. But boy, other than that, when I started as a lawyer, it was David Ball on damages and some VHS tapes from Jerry Spence that,
Yes.
I
I
was
think
very
Eric had a book out by then, and there were
right.
one or two other things. But when I first wrote theater tips,
Yeah, which is I have.
people, is that the first one? I guess that's
Oh, this is the third
the
one.
third one. When I first wrote the first edition, people said to me, David, nobody wants a strategy book. They need books about the laws changing every year. Who's going to buy a strategy book? Nobody even knows what that is. I sort of think if I contributed one important thing to all this, it's to make both publishers and the good lawyers see there is a hunger for this sort of thing that's out there. Because that was not understood then. That was not my goal. My goal was to get work as a trial consultant. But I think the accomplishment is for the attorney who wants to become greater than they thought they could be, the sources are on the shelf right behind you, Aaron. And,
Right.
and then we have the same thing in webinars and seminars and all sorts of things. And the only thing that gets in the way is we're in a period where people are not reading. And it's
Right.
really scary when somebody ignores all that wisdom. There's even an author who wrote a trial strategy book who tells her people that she works with nobody should read any books. And I thought, this is the most outrageous thing I've ever heard. Not just somebody saying it, but an actual person who wrote a book. That's what that person thinks, that's fine. But it's like there's a gold mine over there. Why are you walking by it? And when you really step back and look at the universe of people who practice trial law, even trial guides, which have probably got the biggest collection on the planet of people it's in contact with, that's not even most of them. There's a lot of people who it never occurred to do anything other than to go to the mandatory CLEs, pay a little bit of attention while they do their emails. But what I hope I've had a hand in doing is that there are so many people out there now who are hungry to get better. And we are seeing that bear fruit as we're looking at the kind of results that a Mark Lanier, a Nick and Courtney Rowley, Brian Panish, there's people like that all over the country. They're not all getting $150 million verdicts every time, but there's people of that quality. You're there. You don't need to be anymore as gifted as, say, Jerry Spence is to have an enormous opportunity to do justice for your clients that would have been considered. When I got into this, if somebody got a verdict of $100,000 for a wrongful death case or a lifetime of injury case, they got $200,000 because that's worse. It was considered a wonderful victory. And
Mhm.
then along comes tort reform, which is still with us and about to re-explode on us. But the number of lawyers out there now, most of whom nobody's heard of because they're not writing books and but they're not getting the $50 million case, but they're getting the $5 and $10 and $15 million cases. And on the very small cases, the what's called soft tissue cases and that sort of thing, seven-figure verdicts are not at all rare anymore. They were unheard of before that. And that's primarily because lawyers, and I hope the young lawyers understand this, have seen that when you got a Keith Mitnick or any of the others, giving you the way he does his cases, and they ain't magic, and you don't need to be brilliant. Some of the things you do need to be brilliant. You need to be a masterful person in the courtroom to pull some of the things off that those folks do, but not most of it. And when Keith talks, listen, absorb it. When Brian Panish talks, listen. I mean, I don't know anybody who more valuable to this than folks like that. And it's not just the rallies, it's not just those two or three people I'm mentioning. Those are examples. There's so much richness out there. Even what I might consider the mediocre books have great stuff in them. They just don't have as much great stuff as, Trial by Human or Keith's books or something like that.
Mhm. Yeah, I gotta say, I mean, just my observations in running trial guides for the last 20 some years is there are some people that really get into it and they read the books and they apply it and they work hard at it, and those people are incredibly successful.
Yeah,
Uh,
you and I could name a bunch of them
yeah,
who we've watched their careers go from, yeah, to they're the paragons.
right. And I think that part of well, you tell me what you think about this. Part of the issue is we are not trying the number of cases that people in, say, the 60s, 70s were trying. And I think that part of the benefit of the books is it gives you this wealth of knowledge that you can apply immediately without getting that through courtroom experience yourself.
And that's the problem because so many cases have been settling. Um, and the more scared the defense gets at you, the fewer cases you're going to do. And that's sort of what you want.
Hmm.
If you can get $50 million or 10 mil or whatever without having to try the case, then you've got it. And the client's got the money right away. So, yeah, I think that's true. There are not apprenticeships to the extent there used to be, where somebody
Hmm.
could work in an office and get dragged along and start helping in all these trials. And pretty soon you got Atticus Finch, who I must remind you was a loser, and he could have won that case. If he had read Rules of the Road, ruled out, I mean, he would have won that case. And if a lot of other lawyers had read Rules of the Road, uh, or in fact anything else that Rick wrote, not just with Pat Malone is as gifted as they come, but anything Rick writes is going to help anybody get better at what they do.
Yeah.
I think that's my continuing theme right now. Don't go to trial without having sat down and go through those are the books, resources, CLE notes. Go through them again, and now with this case in mind, because there'll be stuff you never thought about, because it's there, and it's so frustrating.
Hmm.
I see lawyers who don't do that. Well, I just never have time. Make time. This is you got one life, and don't sit there and say, "Oh, Rowley or Panish, they're lucky they get these cases." They didn't always get these cases.
Right.
Randy McGinn, I can name BB people like that, or on the consulting side, somebody like my partner Artemis, where the level of work that people put in to get better and better and better really pays off in this business. It's not like acting, where you can work your butt off and still never get that lucky break. You can do well by working hard as a trial lawyer if you were smart enough to get through law school. And I say you will if you work really hard. Don't just read the book, learn the book.
Hmm.
I'm not seeing that fail yet.
Yeah. No, I'm seeing the same thing, and I would say, many of our customers that have become the most successful are people that are just working really hard at it. They didn't go to great law schools. They didn't grow up in wealthy families. They came out of nothing. And in some ways, they're as much or more so the American dream, frame,
Yes.
success story than the clients, that we work with sometimes. But
Yeah, I
uh,
hate to sound like
it
that,
takes work.
that old conservative mantra, work harder and you'll do better. But this is a field in which that's true. There's a
Hmm.
lot less luck involved than in fields like the theater.
Yeah.
There's luck involved with every single case, of course, but
Yeah.
your shot is don't give up your shot.
Yeah.
You got to work for the shot.
So I'm going to move on now to this book, which is for those of you that don't know, the second edition of David Ball on Damages. It's a much thicker book than the first version, and I just wanted to ask, what kind of influences and experiences had you had between those two writings that now took you to develop the concept much more?
Spending time in courtrooms a lot more than I did before I wrote the first book.
Hmm.
There's a fella that you know about who's got some stuff in Trial Guys named Gary Johnson.
Yep.
Uh, I call him a legendary Kentucky attorney. He was the first attorney to hire me, the damn fool. Uh, he would bring me, he said, I don't, you come in for the whole case. You just sit there from beginning to end. And I would fight with him. I said, Gary, this is going to be expensive. He said, not compared to what I get. If you give me the one right question a day, you're worth it. And whatever his reasons were, maybe he was just lonely. I don't know, but he did. I learned so much, partly from watching Gary, but partly from spending time in trial, 2, 3, 4 week trials, some longer, from day one of jury selection until the jury went out to deliberate. And I did that for Gary over and over and over and over. And as it turns out, it would have been worth doing even if I had done it for free. Because the experience, and you can't get it by watching things on television. People say, how do you become a trial lawyer? How do you become a trial consultant? I say, requirement one, go and watch trials. Not just ones you're working on, but every trial you can find and watch them from beginning to end. All of them, all day long. However boring they get, you need to learn how boring they get because you need to learn to cut through that boredom. And I did that. Well, I did that until probably Artemis picked up the ball and started, my partner Artemis, and started doing that. That's where you really learn. I mean, you don't learn a skill without watching the thing in which the skill is applied.
Hmm.
You don't learn to drive a car if you've never been in a car. You just don't. I don't care what books you're in, the experience of it, and then watching the methods applied and seeing as I talk with jurors a lot. I to this day, well, probably laid off since I finished the rule out book. But the way I learned what I learned for the rule out book, it was the same thing as for the second damages book. You watch trials and you talk to jurors who sat on trials, whether you've worked on those trials or not. You talk to all kinds of jury eligible citizens. I used to go to the shopping mall here in Durham. Um, they probably thought I was just a scary creep until they got used to me. But I would simply say to somebody, I'm doing some research into some jury stuff, and if I buy you lunch, will you sit down? And then while you're having your lunch out here, I can ask you some questions. And about 90% of the people would say yes, because it sounded very interesting. And I just would ask them questions, whatever the topics were I was working with, not focus groups on cases or anything like that, but just attitudes, concepts, what was there. And combining that with, as I started to teach a lot of CLEs, I started to hear people at the time who were teaching the good CLEs, Cusimano and Wenner. I never heard them talk without learning stuff from them. They were amazing. They still are. They weren't the only ones, but they were certainly very important, influences on me, as were a number of people. And I think we all influenced each other an enormous amount in terms of teaching each other and seeing what worked. But the key thing is get into the damn courtroom and watch cases live and sit where you can see the jury. And don't talk to lawyers while the jury's in sight because you don't want them to think you're on one side or the other because then they start covering up from you like this. Don't do that. You're just pretend you're a newspaper reporter or something. Sorry, I banged my microphone. Pretend you're a newspaper reporter or something, or the town creep just looking for a place to sit instead of working with lawyers. That was the sort of thing that was the source. There were individuals who were very important. I learned a lot from Beskin, but if I listed all the lawyers from whom I learned a great deal and who influenced me a lot, I mean, we'd be here for forever. But that's the thing. If you're going to get good enough to have the gall to say to a practicing professional, I can help you, you better know a lot of stuff.
Yeah.
And I didn't. What am I going to get up and block the scene in trial like a director? No. I had to go back to abstract the principles out a little and say, now how can I help you? And some of it had to do with, yeah, where do you stand in the courtroom? Don't do an opening with windows behind you that are open to the sun, or the jurors will just see you in silhouette. That was really where I started. Don't make those blunders that all theater people know and no lawyers ever think about. But then you start getting into strategy, and it's the same thing. So it's hard to ascribe to a single inspiration or a single source. Um, I'm just trying to run back in my mind, and Gary Johnson was a major influence on me because he did the first, I don't know, 8, 10, 12 trials that I was part of, and I was there for the early stuff, focus groups, a lot of focus groups, and every day in trial, and then after trial, nobody rested. We were preparing the next day, and it was always strategy preparation. And I watched that man do, and you have the audio on it. It's called The Most Important Case or something like that. The Winning the
Yeah.
Unwinnable Case.
Yeah, that's what I was going to bring that up. We still do have it both digitally and I'm sure we're
This
almost.
was back in the year one. I mean, it's a long time ago.
Yeah.
A,
I look at
a
that.
$250 million. I'm driving in because the jury's out, and it was a 5-week trial. I hate being away from home. I'm driving from Kentucky back to North Carolina, and there's this long, beautiful hill that you go down from Virginia into North Carolina, and you finally feel like you're home again. You know, all that crap is behind, and Gary calls. It was the first cell phone I ever had. And he called and he said, well, he said, we failed. I thought, oh shit, what do you think? I said, well, what happened? He said, well, I asked them for $500 million, only got $250 million.
Mhm.
$250 million 25 years ago, 20 years ago, in a county that you could have bought 3 of for that amount of money, forever dispelling the notion that, oh, they're all poor, they don't give big amounts of money. And it took a Gary Johnson doing it. That sort of thing was very inspiring. You can change the world in this business. And I'm not a lawyer. I could not be a lawyer. I have no social graces whatsoever. I would, and pardon me for saying this on this video, but I know that I would tell a judge to fuck off in front of the jury. I know I would do it. I've done worse things than that in public, in groups. You may have heard of some of them, but I don't have that temperament to both think at my best and stay cool enough to do my best. I'd end up in jail for telling judges to screw you.
Yeah, generally frowned upon.
Yes. Well,
Yeah.
and I know I'm just not cut out to do that.
Yeah.
And that's why it never occurred to me that I should be a trial lawyer, because I think that is an essential part of the skill if you're going to be anything other than, just getting somebody out of a speeding ticket. So I thought the more I did of it, the more I thought I can change things for the better for a lot of people, just like I could in the theater. I was a director. I ain't getting up on a stage and acting. What do you think? I'm crazy? That's hard. But as a director, I could sit back and make suggestions about all the things you should be doing. And so you got up and you'd be a much better actor. And if you were a better actor, I'd say, see, he listened to me. And if you screwed it up, I'd say, he didn't listen to me. So it's a really safe position to work out of, because I can always blame you trial attorneys, which I don't do. I don't think I've ever blamed an attorney I've worked with for losing a case. There's too many ways to lose, but that is where I think I was driven. I loved making money more than I was going to make in theater. Although as I said, I had a very lucky career in theater. But I certainly loved, the ability to have more money than I've had. But at a certain point, that stops being a driver, and it really has to be something else. At least it did for me.
Mhm.
Certainly, at this point, I could care less. My criminal work is almost all pro bono. I mean, when I could take money from some guy that's not letting out on bond, so he's stuck in jail because he doesn't have the money to pay the bond. So how much money am I going to ask him for? So most of that, not all of it. If they got the money, I want some of it, but it's something else has to drive you. Something it can be something selfish, but read Rick Friedman's Beyond Technique, and you'll see what I mean.
All right.
It's about what can and should drive everyone in this business, especially today, because without getting into politics, we are in trouble. I don't have to say anything more about this world than that. And one of our, as individuals walking around the United States, we need lawyers today to be there for us, civil and criminal, more than at any time that I know about in the nation's history. The very fact that that protection is there is keeping a lot of very destructive forces from getting us. We desperately need what the people watching this kind of video are doing. So if they're starting to feel irrelevant as the years go by, no, it is more important that they learn how to do the best job they can do than it ever has been. You've got to. That's this generation's fight. And you should feel damn proud that you took the trouble to be able to position yourself, to be able to put yourself out there as a blockade between the great powers in the country and the individual, between the government and the individual. Because without that, I don't even want to think about it as much as I think about it.
Yeah. Yeah.
That's, I hate to say, building off of something that ugly is inspiring, but it sure is. One more day.
Well, I wanted to get to that because you can make a lot of differences in your life, but and this is, I'm going to pick this up again. This book became, I think, in this version, probably much more than the first, such a significant point of impact for tens of thousands of lawyers in representing injured people. You did more good with just that book alone, I think, than you could have done in a lifetime doing things.
I think the timing is exactly what you say, because it was around that time that it occurred to me that if I ever wanted to do good in the world, this was my ticket. Not doing a brilliant production of Hamlet. That was great. It was wonderful. It was fulfilling. It was all that stuff. But it didn't feed the kid. It didn't get the medical care. It didn't control the kind of chaos you deal with from corporations and insurance companies. This stuff does, and it ain't just me. I feel part of an amazing team. I think of myself as a coach, and maybe not Belichick, but a coach. And that's extremely fulfilling. And it's why I say one of the most exciting things to me is watching a lawyer do great work. And I don't care whether I got him there, or Jesse Wilson got him there, or Artemis Malakpour got him there, or any of those other people, Joshua Carton. A lot of people help those people get there.
Yeah.
Nick Rowley will say the people he honors in the world the most are the people who were his teachers. And I believe him when he says that. He's not being artificially modest there, because I see how he does his cases and I see where it comes from.
Yeah. Yeah. So I'm gonna move forward, but then I'm gonna move back.
Good. I got a book called Backwards and Forwards. That's a good ad.
You and I met through this book, and this is the original version of Rules of the Road
Mhm.
that I printed in Kinko's after editing it in a small number of days. But in the process of getting the first review quote, you and I met each other via email and spent
I
many.
don't, that's a long time ago.
You and I spent many evenings corresponding late into the evening. We seem to both be night owls, but I found a kindred spirit there, and you've been a huge supporter of Trial Guides ever since then. So I just wanted to say thank you for that. The
I
company
didn't
would
really
not be what it
support
is.
Trial Guys. Trial Guys was so much good to me and was doing so much good. It was a synthesis, I think. I didn't set out to support you, on the other hand, by taking Damages 3 and putting it into a context that I loved, and not a, I don't want to say anything bad about the first publisher, but it was in substantially better hands with you guys. Substantially. I mean, just no comparison. And I know that was not easy to do. And I know that was not, I know it was expensive to do that, and you did that. So personally, I'm sure I feel more of a debt to you than almost anybody else in this business. I like to say it's because you had vision. You knew, but no,
Oh,
I
I
don't know
did.
why you did it. You're crazy.
Yeah, I know. Well, let's go back to this. Rules of the Road is something that you ended up becoming a huge proponent of and spoke about probably even more than Rick and Pat did. How did that change things in terms of your view of how to try?
Enormously. One of the things I've always been interested in as a working tool in this business is what are the black and white things that we have, reframing how we present the law, for example, taking ordinary care from its commonly assumed meaning to be just an average level of care to the point where its second safest level violates ordinary care. That's a pretty good gymnastic trick, but it's true and it's the law. But you have to learn how to do that. But that sort of thing really appealed to me. How do we get as much clarity? The jurors are in a quandary. They are confronted with a huge amount of information on a playing field with rules that not only they don't know, but when they hear them, there's too many of them, and they don't understand most of them. And when they do understand them, they think some of them are crazy. Just get a board game sometime, a complicated board game, and read the inside of the cover if they still make such things. Just read it once through the way the judge reads the instructions to you and see how much of it you remember. You won't. And yet we're expecting them to go. So my goal has been to find the analog, the digital things. Yes, no, is, isn't. The simple, boiled down things. If this, then that. And rules of the road. Obviously, Rick and Pat did not invent rules. And obviously, they weren't the first to use rules in trial, but they were the first to teach it so that everybody could start using it the next day in trial. Now, to use it really well, it takes more preparation, but nonetheless. And it was such an important step in advocacy, because it gave jurors a framework, here's how we do this. It armed the jurors on our side. We had to learn to be careful not to accuse the other side of the defendant of violating a rule that we had sort of violated too. So yeah, there were things you had to learn, but they taught that. And we found other ways to teach that, and we found other ways to use the rules. I started applying the rules, and I never would have done this, to how the jurors follow the law. Rules that jurors have to follow, and that's how I learned to be able to get jurors to want to decide a case based on preponderance. And that is certainly how the basic rules of the road thing is where I learned how to get jurors in criminal trials to want to find and apply reasonable doubts and to fight like blazes with a juror who is trying to decide the case in any other way. And if they do that, you're going to win almost every case because there's always reasonable doubts without raising the barrier to beyond reason, I mean, to something higher than the law says. And it works. I mean, it's always worked. It's a good persuader does not go on and on and on. A good persuader says, here, this button, if you understand this button, that's the case. And Rules of the Road gave you the button so that something like the rule out method, it gives you the button. Something like getting the jurors to decide on the basis of preponderance. It's not about explaining the laws to the jurors. It has nothing to do with explaining it. Yes, you have to do that, but that doesn't get them to do it. It really doesn't. In fact, you can get pushback from that. But it can be done. And that's both a theater thing, to be able to get an audience to feel the way you want them to without appealing to their emotions. And it's a Rules of the Road thing. And the most important thing that's in the Rules of the Road book is the rule has to be such that the other side, this is absolute brilliance that comes out of Patton Rick's book. The rule must be such that the other side must either agree with it or look foolish, stupid, or dishonest. Because once you're there, you're there. You've got the layering at the beginning. You should be on the way to winning within the first 3 or 4 minutes of your beginning of your opening. When you use that, it's more complicated than that, but fundamentally, that's how important that book was. The only thing I didn't like about it was its title, and I didn't like its title because so many people thought it was for automobile cases.
Right.
But you guys took care of that eventually, and without changing the title, but the marketing made it quite clear.
Yeah, yeah, and it's yeah, you gave us important insights on that. I want to go back to something you were just mentioning. I mean, one of the things that
Well, that's why I once said you should take your book's title from, what is it, from Safe Hands to Boxing. What is their book?
oh, from good hands to boxing gloves.
If I wanted it from what kind of hands?
Good hands.
From good hands to brass knuckles, I thought would have.
Right.
But
Yeah.
that was long after your book had a reputation for itself, so you couldn't change the title.
Yeah. Hey, so I want to go back to damages too. You know, one of the things that sort of stood out to me in that book was um, you and addressing the issue you were just addressing. You kind of changed the way that I think that the plaintiff's bar typically addressed opening statement from, you know, poor me and focusing on the plaintiff to focusing instead on the juror conduct. And I think that was a fundamental change and one that maybe surprised a lot of people, but it seems to be much more effective.
It
Can you?
is very much more effective, and I can't claim credit for the idea. I put it in a package because Damages 2 was sort of foregone it was going to sell pretty well.
Mhm.
I put it where people would see it, but it's a fundamental principle in theater. And I'm not certain of this, but I think Greg Cusimano and David Winter did some research on it, as had some other people. But it comes down to a fundamental, technically speaking now, but what's called an internal bias, which is you make your decisions based on the information you have at hand. And 2, once you've started to make that decision, you tend to stick to that decision unless something comes along to change it. So when you start with telling the story of your client, the jurors know they're there to figure out who did something wrong. So they'll be sitting there saying, I wonder if that person did anything wrong. And then you've got biases like the fundamental attribution error that says, that would never have happened to me because I wouldn't have driven that car, or I wouldn't have gone there, or I'd have checked that doctor's credentials, yada, 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 which nobody would have done, but they think they do. But that fundamental, the first thing you hear is tremendous, not the first thing, but the first things you hear, the first topics you hear are tremendously influential. The beginning of a case is about what it spends its time being about. Well, if it's about your client, what people used to do is say, look at this horribly injured client. Let's look and see how she got that way. That's good. That's good. Except when they hear about all those injuries, people think, I don't want that to happen to me. I am more careful than that would, and that gets you in trouble. And it happens, I don't want to say all the time, but a huge amount of the time. So when you start by focusing on the conduct of the defendant, you're in a much stronger position. And that came out of, it may not have been Cusimano and Winter, but I don't mind giving them extra credit anyway, they deserve it. But it came out of somebody's research back then. And I knew it was true from theater. I knew we could, with that concept alone, you can play games. You can toy with the jurors' emotions all the way through. One of the very best movie script writing books is called Save the Cat, which creates an impression you want right at the beginning, because that impression will stick through thick and thin. Well, if you talk about your client first, so that the jurors are thinking, wonder what she did wrong to get herself in that position. Oh, she was driving, what do they tell themselves? That comes first, and that impression sticks with them. It'll pop up in deliberations.
Mm-hmm.
So you got to be very careful about where you start the story. It's one of the things I'm hoping we can explore in the thing in the fall with storytelling. I think we got 5 or 6 different really good story people on board to help with that.
Yeah, we're looking forward to that. Hey, I'm going to jump back a little bit. So, after you and I met through Rules of the Road, somehow we talked Nita into allowing me to do an audiobook of David Ball on Damages 2, and we were in a recording studio together for a couple of days in North
That's,
Carolina. I came back, I think, about a week later and struck more people for cause than I ever had in my entire career. And then the judge said, "Okay, Dr. DeShaw, no more for you," and they moved me to my peremptories. But during that, I think right at the end of the session, you said, "Hey, I got this video with Gary Johnson, who you mentioned earlier, called 'Winning the Unwinnable Case,'" and so we put that out together many years ago now. Um, one of the concepts that really stuck out at me from that video, and I just wanted to ask your thoughts on this, is Gary's concept of judo law, which has sort of taken on a behind the scenes discussion amongst great trial lawyers, but I don't know that a lot of people understand using a pre-existing condition in an offensive way rather than having the defense use it against us.
the concept of judo law was introduced. Gary Johnson's. It came about when there were 2 things in the world important to Gary when I got to his office the first time. The first thing you do is hand me a copy of How to Win Friends and Influence People and say, go over back to the hotel, read this, and then come back. And he was right. It is the best trial advocacy book anyone's ever written. How to Win Friends and Influence. You learn more about human beings and trials and all that. Certainly negotiations and working with judges, all that stuff. If you haven't read that book, read it tonight. I don't care if it's your anniversary dinner, throw them out of the house and read the book instead. The second thing was, it was the first or second case I was there working with Gary. There is, by the way, Pikeville, Kentucky, which at the time you didn't want to have to spend the night because there was only one motel and you did not want to spend the night in that motel, but there you were. This is one of those motels with a crack under the door that opened into the parking lot. The crack was large enough for mammals to come in underneath. It was very scary. But there was a real problem in the case. And Gary and I were talking about it, and he taught me what judo law is. And this is way back, and nobody had dreamed of this at all. And now it's pretty much commonly out there, although some people call it other things, so people will think somebody else invented it. It's, you go in your office when you got a really bad problem in the case, and you shut the door and you tell people don't bother you and you don't come out until you have figured out how to take that bad thing about the case and make it a good thing for you. And that's judo, called judo law because it takes an incoming punch and it turns it around, sends it back with more force than it came in with. It is a case winner in case after case after case because you take the very thing they're relying on. Um, it's worth telling, I think, the case that this happened on. I think it's the same case, or wait, no, it's the same case. A guy who could barely do anything without ending up in terrible pain, and he couldn't really do much anyway. Um, they followed him around with their cameras, as the defense will do. And they got video of him in some mountain pool, this is in Kentucky, with his kid, and they're splashing around in the pool, and he throws the kid up in the air and is doing all this stuff. And the defense was going to kill us with that tape because we were claiming he couldn't do any of those things. So first we said, what do we do? What do we do? Then we came up with a brilliant idea. And you know what? This is an unusual idea. Lawyers don't do it often enough. We said, let's ask him. Let's go ask the client, what the hell is this about? And he said, well, he said, that coal company, they basically took away my life. They took away, I can't even sleep. They took away my income. They took away my friends at work. They took away everything. I was not going to let them take something away from me. That's the most important thing. When I was a kid, my daddy took me to that pool and we played. And I wanted my kid to have that same experience that I had with my daddy. And I was not going to let those people take it away from me. He said, I had to pay for it. He said, I was flat on my back for the next 2 days. But, well, don't you wish the jury had heard that? They hadn't because the case settled the next day or a day or two later. But that's judo law. It's not just defending against an incoming missile, it's turning the missile around and pitching it back at them so that it's worse. It's a very powerful technique, and it's a powerful technique because unless you decide in advance that you can indeed think of something, you won't work long and hard enough to do it, but you almost always can. That's judo law. We used it in that case in Kentucky. I don't think Gary does cases like it. It's not just for soft tissue or, spinal cases. It worked in the spine cases because, somebody's claiming a back problem from a wreck. And Gary would ask the jury in jury selection, I forget exactly what the question was, but the principle was, this person got hurt, as opposed to all those people who might not have gotten hurt in that low impact connection, because he's got this pre-existing condition. And they are not entitled to make it worse. Because before, here's the condition he was in. But
Yeah.
that made him fragile. That means, look, if it's a baby in the car, if it's your great grandma in the car, they can't come in and say, well, the baby's fragile because it's a baby, or your great grandma's fragile, so she broke all those bones because she's an old lady. That doesn't get him off the hook at all. Neither does this. So we took the concept of whatever spinal disease the defense doctor was going to say it was there. Yes, it was there. Gary got the more said, I won't take a case unless it was there.
Yeah. And I've heard him say that. And I gotta say, I mean, from my perspective, this is one of those differentiators between people that are just practicing and not reading the books and the people that are practicing and reading the books and like really working at their skills. Because a lot of lawyers will get destroyed on the defense of degenerative joint disease.
Yes.
It's like everybody has it, past, or almost everybody has it past, say, 35. But the genius of like this judo law concept is you say, hey, but for the pre-existing condition, they probably wouldn't have been injured in this low speed impact where there's not much vehicle damage. And so Gary's taken what, has been challenging, both in terms of the low vehicle damage
Yeah.
and the pre-existing degenerative joint disease in the neck. And they kind of like put them in there together, and it turns into a winning argument that you can rely on the jury instructions for.
And then as you fade that into the reptile, you have the next step, which is to say, if you are driving with ordinary care, you're driving careful enough to protect everyone on the road as if they're all fragile eggshells, every single one of them, because you don't know who's in that next car. And you have to drive safe enough to protect them. So you go from this brilliant flip, and it works. I mean, it always works as far as I know. The reason this happened to this person is they were having problems with the spine to begin with, but not the problems they ended up with. This is what made it. Jurors, it's a very easy concept. You don't need an expert to even explain that. You know, if you've got something wrong with your spine, then somebody's going to come along and make it worse. But it was not going to get. The only thing you need an expert to come in and say is it was not going to get like that ever. And here's how we know, or whatever you've got to work with.
Hmm.
That's where that started. Now I've started applying it, and I think Gary does too. I don't care what the issue is. If it's an incoming, law school teaches you to learn how to defend against the incoming. And we don't want to defend against the incoming. We want to make them turn it around and make them vomit on the other side with anxiety and regret that they ever brought that topic up in the first place in civil cases.
Yeah. So you did mention it in passing. I obviously want to reference, a very important book, of course, that you also co-wrote. And, I just wondered what your thoughts are. I mean, it continues to be a source of horrible aggravation for defendants and defense counsel, and even the U.S. Chamber of Commerce seems to be blaming you guys for these nuclear verdicts that are occurring.
It's,
Uh,
it's certainly part of it. I think what Reptile did, even to people who don't use it, they're now people who at least keep up with what's out there. So much of Reptile has what infiltrated is the wrong word, but it's gotten into the way of it, or the way people do a lot of their cases. The basic concepts are there. So yes, that's had a lot of influence, even among people who say, "Oh, reptile, I don't even know what that is," or "I hate that," or "Screw you, David Ball, I get one of those anti-reptile motions every time I get in trial," which they do. But there's a million anti-reptile motions that are out there. You can find on your listservs, or send me an email. I'll send you some.
yeah.
They're all illegitimate. They're very rarely, if you know what you're doing, you won't lose that motion.
Yeah. I mean, can for those folks that never got to see that book or didn't get to see you guys speak, which you spoke a lot, is there anything, that you think is primarily important out of that book that has sort of been incorporated now into the general practice?
It's what I think the kind of awakening that is out there is, and I shouldn't say everybody knows this by now, but they ought to because it's the law. Part of the purpose of compensation is to deter. And jurors, and in most states, you can say that in one form or another. And if you can't overtly say it, you can get most clients to testify about it because somewhere along the line, the other side is going to challenge how badly your client is hurt. And that raises the implication that your client's being greedy. And that opens the door to your asking them what are their motives for being here, to rehabilitate the claims or the implications of greed. That's just one way to get here. They can say, I'm here because I don't want them to do this to anybody else. They can say that. It is a fact in the case, it is evidence, and it is relevant because it goes to their credibility, as opposed to, are they being greedy? And if you don't want this to happen to other people, and almost every client will tell you that without leading them into it. Why are you doing this? Well, I need the money, but also I don't want anybody else to have to go through this.
Hmm.
Almost every client will say that. And they don't have to be very sophisticated to be able to say that and even explain it on the stand. That's fundamental reptile because the jurors now see that there's a purpose to this verdict other than just compensating. And the other side can scream their heads off all they want, but that is its fundamental law, that part of the purpose of compensation is to keep us safe. I don't care what fundamental law book or restatements. It's crystal clear. It's simply the law, um, and that has made that awareness. And I'm trying to find ways to get that awareness more to jurors, because jurors also pick up that thing on their own, and that is a home for the reptile. All the reptile is about is making the world a safer place. That's why in these idiotic anti-reptile motions the defense puts out, don't let them use the word safety. Or here, on a negligence case, negligence is about safety, but don't let them say safety. And certainly don't let them use any rules,
Right.
that sort of thing. As I say, you don't need to ever lose one of those motions. But that concept is historically and legally true. The jury was invented in the first place to protect the community. The jury has always been there to protect the community in civil cases from the forces that would hurt us, and in criminal cases from the government, which is a fundamental thing, by the way. We're not testing we're not testing whether the defendant in a criminal case, we're not testing whether he's innocent. We are testing the prosecution's case. The test is, can they rule out all the reasonable doubts? It's putting the test where it belongs. And then the jurors themselves start to identify in civil cases with why this is important. So you start coming up with analogies like this. They think a rear end collision is very minor. You're stopping at a light, somebody hit you going 12 miles an hour. Yeah, I guess you can be right. Okay, let's give them some money and get out of here. Until you point out, if the car hadn't been there and this jerk who was reading their email on their phone, instead of hitting the back end of your car, hit the three kids in the crosswalk in front of the car and killed them. That's how important the law that they violated is. Now you've got a great damages driver. Why? Not because the damage to the guy in the car is any worse, although it is, because it scares the hell out of him. Now he's afraid of his kids going to school because this could have happened there. I mean, there's all kinds of ways that raises somebody's fear alert, but because the juror now realizes this applies to him. The phrase that I'm proudest of in the reptile is spreading the tentacles of danger in a way that is proper and legal. And I realized afterwards that reptiles don't have tentacles, but nonetheless. And as it turned out, well, there is now one reptile they discovered that does have tentacles, so there.
So
That was the drive to that whole thing. It came from a marketer.
yeah, Clotaire Rapet, right?
Yeah, Reptile. I think it's Reptile.
Rapet. Yeah, I ran into his book looking through my library this morning. I thought, oh yeah, there's the book.
The Culture Code. He's got a few books. The Culture Code is the best of them. And some of his neuroscience is bogus, as is some of what I put in Reptile, the book. But it's a way of thinking about what the brain does, not how the brain actually grew, but how it functions.
Mm-hmm.
The brain evolved, and this is true, as a way for us to protect ourselves so that we could survive. Didn't evolve to listen to Bach and Mozart. It evolved so that we could survive the pressures of trying to survive. And ultimately, that's what it is. The brain is one of the most incredible survival tools there is.
Yeah. So after Reptile, you came out with the third edition, and this is the one that by this point we then bought the rights out to all your
Right,
books,
right.
um, and made sure that the new version of David Ball on Damages was something special, which it certainly is. It's again much larger than the second edition, but part of the beauty I think of it is that you incorporated your concepts about using rules of the road and Reptile and put it together with the David Ball on Damages method, Anything that sort of stood out to you in terms of an evolution?
Well,
Um,
part of it was obviously the rules of the road thing um, was extremely influential for that book. There's a method in Damages 3, I think it's on page 286 if anybody wants to look, called the scales. And that's not the scales of justice. It's the scale of comparative value of a harm to your client. A little bit of harm, a little bit of money, medium amount of harm. It's an extremely effective device. It's been tested. The official, the heavyweight researchers, Valerie Hans and some others, took that concept and researched, does this really work? And when she first told me she was going to subject it to the kind of rigorous, not just the focus groups the lawyers and trial consultants do, but they really do the academic research on it. And it came back being what I was hoping it would be. That's rules stuff. That comes out of the rules, giving the jurors standards to go by. If it's a little bit, you give a little bit of money. It's a medium amount of money. And how to do all that's in the book. But it quantifies non-economic damages in a very useful way for jurors. And by creating standards, be they rules or whatever, it was a very powerful influence on me. And the way to frame it is the way Rick and Pat framed it in Rules of the Road. I mean, frame it to be able to teach it. I have to say that Damages 3 is written before we had what I call the empathy revolution in trial advocacy. And that largely came, in my understanding, and from what I saw, from the Rowleys.
mhm.
When they started trial by human, I knew, if nobody else did, that they picked that name. I didn't know them at the time, that they picked that name because they wanted to be as far away from the aggressiveness of the reptile as possible. And it was a good choice for what they were teaching. And if you watched Nick in trial, that human thing, that empathy, the importance of getting jurors to be able to empathize is so crucially important, and it's really kind of new to the field. Nobody was teaching this until then. At least nobody that I knew of was teaching it in a practical way. Rick was touching on it and then came out with a much bigger, version of it in Beyond Technique, the way of the trial error, whichever comes first, I don't remember. But that notion of the great frustration in my life is I have not been able to write the empathy book that I wanted to write. It's just, I got all the stuff. I just haven't been able to find the framework to make it work in a way that people can learn it. Someday I might.
Well, let me raise this because you did end up writing Damages Evolving with the Rowleys, and
Yes. And that was why. That was, when Nick came up with that idea, I thought absolute dynamite. Because when Artemis and I first heard about the Rowleys, we kept asking, how the hell are they doing this? And so
yeah,
we started paying attention and we saw how they were doing it. And I have learned a great deal from Nick, both about this business and just about being a human being, as I did from Rick Friedman.
mhm.
And I'm the kind of 50s and 60s brat who's not into this self-improvement stuff. Yeah, get it away from me. And yet, there it is.
Yeah.
Most people who grew up like Nick turn out to be jerks. Nick turned out to be a human being.
Mhm.
Um,
Yeah, when you say that, I know something. The childhood essentially down on the border, getting beat up every day. Is that, facing the bully every day? Is that kind of what you're talking about, or are you talking about other?
yeah, it's that I'm talking about when he was very young, and at the same time, you're brilliant. And it's all the ingredients to be a jerk. you know? And instead, there's such a great humanity there. Um, it's very hard for me to say that somebody that much younger than me taught me so much about how to live a life.
Hmm.
Just by watching. I mean, he never sat down and said, David Trey would never do that. But just what I saw work for him. Some degree, I learned that from Joshua. Um, Michael Leeserman is becoming an influence in that regard for my life and some other people. And you get a lot of that out of the theater because theater is ultimately about nothing but putting empathy on the stage. It's all it is. But it's a way of bringing that back home. So it's not just something I do, but in a lot of ways, something that's more important to me in terms of both techniques that you use and in terms of how you live your own life. And why it'd probably be better if I didn't have any of that, because then I'd worry a hell of a lot less about the current political situation.
Hmm.
The people that this is going to hurt the most ain't me, it's other people. And
Hmm.
yet, my agony, and not just mine, but many of us is, if there's such an apostrophe S, that's an empathy thing. It's not just irritated what some jerk in the White House is doing.
Yeah. Um, I hate to change topics, but I'm going to go
That's
back.
okay. No, don't let me babble on about that anymore.
No, I know. I want to go back to something about damages three that I hear, once in a while, particularly from younger lawyers, and that is the prescriptive openings and closings that you kind of, lay it out for us. And I gotta say, it's very fundamental to the way that I try my cases. But there's been some, questions over the years like, hey, can I stray from this? Should I not stray from this? And I just wanted you to be able to address that issue. Why is it, how did you create it, and why does it make sense to sort of stick with the prescriptive openings and closings that you suggest
You,
in.
the fundamental outline of that, and I think I say this in the book, I better have, or I'll be very angry at myself, comes from Diane Wiley, who was one of the very early trial consultants. She's with the Jury Project, which is still a pretty incredible group of trial consultants. Um, and she had the basic, I've obviously done a lot with it, but she had that basic format, which I learned from Gary Johnson, by the way. Um, I don't care what somebody does when they get up there, but it better be at least as good as the technique that I teach. And lawyers had nothing. There was no framework for them at all. So they were getting up and giving these stream of consciousness openings that unfortunately were the stream of their own consciousness and not the jurors. They were, good morning, ladies and gentlemen. When they wheeled her into the OR, her hemoglobin rating was 93. Jurors, what the fuck did you just say? There was no concept of what you can do with a structure. And they were all at sea at the beginning of the process of writing an opening. So I thought, well, a structure will give them an easy way they can plug everything into, and I'll frame it in the best way that I know communication works. Will there be exceptions? Sure. But the rule is if you change something, make sure it's better, it's more persuasive, it does what you want, and not just you wanting to babble on all the stuff you found out in discovery. So it was the same when I was teaching acting. Um, I was a very technique-based teacher. And the reason it worked for professionals, I said to them, you don't have to do this. I should have said this when I first proposed that opening. You don't have to do this. But if you do something else, make sure it is better. Don't just do it because it's easier. Lawyers are busy as hell. By the time they're writing their openings, they're so busy they just want to get all that on paper, and I'll explain it to them fine in trial, without realizing that the most playwriting, which is my basic influence, is not PLAYWRITING, is WRITING. G-H, like a write, meaning a person who does a plowright. A playwright is a person who crafts things. That means structure. How are you building this thing? What's the architecture of this? And all I wanted them to do was either do this or do something better. And I probably was a little bit too much on my high horse and making it sound like there is no other way to do it. What I was giving them was the best way I knew to do it. If you are a Jerry Spence, a Gary Johnson, or whoever, probably what you were doing on your own was perfectly fine. But 99.9% of they had no idea how to do an opening. And this is just a way that you could all do it, and I know that works. It's pretty hard to go wrong with it if you stick to the outline. And I would tell people, if you're going to change it, let me know and let's talk about if it's hurting something. Because every word you say in an opening depends for context on what you've just said and what you said before that. And you can blow it by putting the wrong thing in the wrong place. And I can either write 3 books on all the considerations that went into the development of this structure, or I can just say, here, do that. And that too easily evolved into a do what I say or die. My statement now is, if you want to change it, have a reason other than this is too hard. One lawyer I know did something that he started reading his openings to the jury. Oh, it's just too hard to learn them. Just too hard. And there's not a person in the business of communication and persuasion in the world who will tell you it's okay to do that. It so diminishes the impact completely. Even if you're a good reader, it just takes it way down. So if you're going to do that, what are you doing? You're solving the problem that is hard for you. And I say, oh, poor baby. So it's hard. You're in a hard business. Actors have to learn their lines. You can put your headings down there and look down what's your next heading and know it well enough. You can almost do this off the top of your head one. So there's other ways. There are some very effective ways to start an opening in the right cases that are very different, where you might start with the injuries to the client, but you better consider what you're losing when you do that. You're losing the advantage of keeping jurors from thinking about anything your client might have done wrong. Now, in some cases, that's fine because your client was not involved as a doer of anything. They were a bystander. They were a passenger in the back seat. So that doesn't hurt as much then to talk about them in advance, in some cases. But I didn't know how, and I still don't know how, to convey everything somebody needs to know about making all those decisions in a book.
Mm-hmm.
So I would say, if you don't have something better, I work with lawyers all the time, coaching them through their openings, and frequently it'll be a very different kind of opening. And sometimes there's really good reason for it. So it's me being a bit full of myself. When enough people have said to you, oh, that damages 3, that's the Bible. And I said, well, I don't live by the Bible. I'm not sure I want this to be the Bible. But you really do start to think, I must have just ascended from Mount Sinai because I know the truth. I think I slipped into that. Certainly with the Reptile, I did. Because that was such a powerful damn tool. And you did have to do it right, but there were people who made a lot of good improvements on Reptile without even realizing they were using Reptile. And that's what I think age has taught me. And I should have known it because I knew it from when I used to teach acting. And some kid who doesn't know anything is going to come and do a scene and I will learn more about acting from. So I hate that it was that proscriptive. And yet when I saw most of what people do when they weren't using it, I was saying, God, I wish they'd done it. I wish they'd use it because this doesn't work. If Eric Oliver comes along and makes some changes to an opening, He knows what he's doing. He's
Right.
not going to make a misstep. But he spent his life studying nothing but that. He's not taking all this time to do all the other things you trial lawyers have got to do. Um, so this is a way to just say here, do this unless you got something better.
Well, one thing I would say, and I'm a huge fan of David Ball on damages, which I'm sure you're probably aware of, but I gotta say one of the reasons why is, and I'm not talking about just the prescriptive opening or closing, I'm talking about your knowledge from watching trials and doing focus groups really provides such an in-depth discussion of all these topics that a person without that level of experience does not have in thinking about how a particular jury belief might play into their end outcome. And I will just say this, I mean, for you and the audience, I tend to review that book, either an audiobook or the book itself, before every trial. And part of the reason I do that though is to remind myself all of the possibilities where a juror could go sideways on me if I don't address an issue that you've already raised as being a potential problem. And so I'm going to bring up one of my first $1 million verdict. I failed to address an issue of who else is going to pay for the loss. And interestingly enough, the jury returned a verdict that was way over the policy limits anyway, but it was much less than I expected for the case. And they came out after the trial and they said, "Oh, well, she's such a good Christian that her church is going to take care of her for the rest of her life." And I thought, "Oh my God, I got rushed during jury selection.
Sure, sure.
I got rushed during opening statement, and I didn't address some of those issues in your book that I should have addressed. And the result of it is I probably got a verdict that was $3 to $4 million less than I should
Yeah,
have."
and that's easy to happen. The person who's scary good at spotting those, I'm good at it. I know how to do it. But the person who's really scary good at it is Artemis, um, who's really good at saying, you think that's good and it sounds great, and it probably is great, but you better think about this thing over here because this can bite you. And she's scary good at that. And of course, once it's mentioned, once somebody lays the problem out on the table, in a brainstorming session, that's mainly what I do now. We call these things work days, and Artemis and I sit down with the trial team and we brainstorm the case. And Artemis goes and does the traveling and the focus groups and the jury. So I sit home. Um, but once the problem is out there, a great solution generally arises. But if you ignore that stuff, um, the other thing that attorneys do that I think is a bit scary is Artemis or I will say, well, what about such and such? They'll say, oh, well, the defense is never going to say that. Well, screw the defense. What are the jurors going to think? The
Mhm.
jurors self-generate more ideas than the defense ever gives them. And so we have to take into account what we learn from focus groups and experience and the logic of it. What are they maybe going to say about it? Are they going to see this very differently? And the lawyer's so close to the case, it's very hard to step back and see that. And after a while, we get that kind of close to the case. So it really takes careful looking it's like, what a red team is? They would send in people to try to show what's wrong with something. They try to hack into your system. It was developed in the Middle Ages because it was called a red team because I think it was cardinals who there was a proposal to make somebody a saint. And so this team would go down and research this person's entire life to find the reasons why they should not be sanctified. And that is the solidest way to seal all the holes. Once you know what the holes are, you can fix them in your case, I hope. And that's what gets really important. Otherwise, you miss the stuff. Most cases that people lose, they don't lose for the reasons they thought they might lose, which is a really odd observation, but it's kind of true. I don't want to say most, I haven't done the statistics, but it's certainly a great number of cases that people lose or do badly in was not for the reasons they were afraid of.
Hmm.
Um, and
Yeah.
this is the way to look at that. Once you can find out what it is, then you can judo law it or do whatever you need to do.
Yeah. Hey, another frequent question. I'm just going to ask it. I already know the answer to this, but there has been some question about whether this is just the new version of this, and
Oh,
it's
not at all. The back of the last chapter, one of the last appendices in Damages Evolving, is updates. You just cut out the page and paste it into your Damages 3. Um, but no, the two books do not cover the same ground. Some of it, but not much of it. It's it supplements it, but it mostly goes off on totally new things.
Mhm.
Especially, that's true even of my stuff, but I wrote that with three other people.
Yeah.
Um, I wish that when people read the book, they do what you do. That should be one of the books you leaf through at least after you've read it the first time before every trial, because there is so much in the. I can never remember the lawyer's name who wrote the chapter on appraisal. I don't know him personally. It was somebody Nick knows. Um, but there's a chapter called appraisal, which is one of the best damages arguments I know.
Hmm.
Um, if I were evil and mean, I would have erased that guy's name and put my name on it. It's really good. Um, which is another thing I like about Nick. He's secure enough to bring in people, to do stuff that people are going to say, that's the best chapter in the book. Not one of Nick's, not one of Artemis's, Courtney's, or David's. But this was such an amalgamation. It was to me. I was on a dream team that I learned so much from those people. Um, there's just so much damn good stuff. The concept of duty,
Hmm.
violation of a duty, is so much worse than the violation of a rule. The concept of respect. Respect is one of the most important needs we have, other than food, water, and procreation. Respect is so crucial. It's totally an unconscious drive, but it's there. If I humiliate you in public, you will remember it for the rest of your life. If I slap you, the thing that you will remember for the rest of your life is the humiliation of it, not the pain.
Hmm.
The disrespect that your client is subject to because of the act of negligence and then because of what the condition they're in later can get you more money than physical pain.
Hmm.
And the book has just got tons of that stuff in there, and a lot of people have digested it and use it very nicely. Um, a lot of people have read the book and taken and use it, but they're not. There's so much in there that you've got to go back and look at it. I think Damages 3, it's a good idea to do that with too, as with some other books. But that book is one that I wish people would do that more with because it makes such a difference in how you frame your damages. It's and I don't feel like I'm self-praising here because so much of that stuff ain't mine. Uh,
Hmm.
but yes, to answer your question, it is not to replace Damages 3. If it was, it would have been called Damages 4. And in fact, that was a possibility at one point. We're thinking of that, and then we just realized this is just going to be. I didn't want people to have to throw away Damages 3 because virtually all of it still plays. And so what am I going to do? Put all that into another book and then change little bits and pieces of it? And so if all your notes are in there that you've been writing in all these years, this just seemed to be a more
Yeah. Yeah.
practical way.
So I want to move on to a different topic, and that is focus groups. Now, you had written an early book on this, which is here.
Mm-hmm.
It hasn't been available for a long time, I don't think, but you did this video. with Deborah Miller and Artemis. Uh, I think in 2009, it was somewhere around that whole
Mhm.
period. We released Rules and Reptile and Damages 3 all within a couple year period of time, and the focus groups video was part of that. Just going to the topic itself, what are the goals of a focus group as you go into them generally?
I want to find out what the things are that are going to have the most effect on the jurors. I don't use them as predictive tools. You can start to do that with some of the big data research if you combine it to an extent, but you can't use the big data research alone to do anything, I don't think. It can be very misleading, as can a badly run focus group. I did that book and then the video because so many lawyers were finally starting to do focus groups. They couldn't afford a trial consultant, um, but they were going to do them. And I thought, well, if they're going to do them, they might as well do them well. And that early book and the video is how to do them if you're going to have the jurors deliberate. It's not if you're just going to tell them about the case and debrief. So in other words, it's just about one, and that still is the gold standard of focus groups. You still want to do that. It's closer to a mock trial, not quite as elaborate. Um, it's it doesn't predict what your verdict is going to be. It doesn't even predict who's going to win because if it's a well-run focus group, you're probably going to lose it because you want the strongest case. You want to do a better case for the other side than they're going to do because you want to see you're crash testing your case. And as has been pointed out, you don't crash test a car with pillows. You crash test it with sledgehammers or by driving as hard as you can into a wall. You want to see where am I in danger? You want to see what are the strong points. It can tell you whether to settle because it can show you your serious problems. And then you can say, do I have a shot at solving those problems or not? It's not just some vague thing about can I win or lose, but those are the problems that are really getting the jurors all exercised. Can I do anything about them? And it makes no difference who we've done a focus group for. I mean, obviously, we work with lawyers at every single level of success and age and all that in the business. And every single lawyer for whom we've ever done a focus group has said afterwards, I never thought of that, and it'll be some pivotal thing. I never would have thought of that. And that is one of the things that has changed enormously. Nobody was doing focus groups back then. The National Jury Project and a few places like that was doing focus groups. A handful of lawyers was doing them early on, and doing them badly, I
Hmm.
think. By badly, I mean in ways that were going to mislead them. The results can be so seductive that you want to believe them even without a focus group is kind of a social science experiment. So you need to understand how to do a social science experiment, or you can simply mislead yourself. And there
Hmm.
are a lot of, and every consultant does some focus groups differently because we all learn from different things. But there's fundamental things you can learn. Um, and so I don't care how people learn them. By using a good consultant, you will learn more than you'll ever learn on your own because, again, that's something the consultant specializes in.
Hmm.
There's a handful of lawyers who do these very well, um, and have used them for their own practice, and they got so good at them they started doing it for other people. Cusimano and Winter come to mind, but that's very very rare. It's not the same skill set at all. Um, David Winter comes to this as a social scientist, um, so he sort of knows what he's doing. And that's why people have learned. So I certainly have. I mean, they were one of the big influences I said that before. But there is so much to be learned, not just about the case you're working on. One of
Hmm.
the pieces of advice I give people, especially younger lawyers, but really anybody, you need to watch deliberation focus groups, preferably, at least 3 or 4 times a year. They don't have to be on your case, but you want to see those deliberations They are all available somewhere because when people do deliberation focus groups, they're videoing them. There's a video of the damn thing. It exists. So you can imagine if you have watched, and typically when we do these things, we break it down into groups of 6 because you hear them talk a lot more. Even if you've got a real jury of 12, we do 6 or 7 because they'll all talk a lot more. And we'll do 4 of those usually at the same time. We give the case to 24 people and divide them in a group of 6. And then each one is separately recorded because nobody can watch all 4 of them at the same time. But then you've got them and you can go back and forth. But they're out there. People have them. And imagine it's about a 2-hour deliberation session on the average, 2.5 hours. If you do a full day session, it would be 2.5 hours of deliberation. Imagine if you had watched one of those a month for 5 years. You would have seen dozens of deliberations, real deliberations, not real trials, but jurors doing what they really do in deliberations. And you will develop a feel for how jurors think and work more than you'll ever learn any other way. That's really where ultimately, you are nothing but a person who's feeding a jury. That's all you do for a living as a trial lawyer doing jury trials. And you do that without having any idea what's going on in the jury room. And you make your decisions about what to do next time to avoid what on the basis of just how did the last trial come out? Not on the basis of what went on in the jury room, which is one of the reasons some of the consultants, like Artemis, and not just Artemis, many are so really good because they've watched so many of these things. It becomes as familiar to them as something they do every single day. It's part of their fiber. Very few lawyers have that. They've just got this external, they can watch all the traffic go by, but they have no idea how to drive the car. And that's more important even than working on it just for the case you're working on, is to turn yourself into that magnificent creature that has that fundamental, implicit, instinctive feeling about what juries do. That's the most powerful weapon I can suggest for any lawyer. It takes 4, 5, 6, 10 years, but you'll get there if you're watching yours or somebody else's. Hey, Sam, I hear you did focus group. Can I just come look at the videos, or I'll wait till the case is over? Can I just watch the videos or borrow them from you? Sure, lend me yours too, and then you go back and forth with this, and there's more out there than you can shake a stick at. This is one of the really valuable things. The other valuable thing is to be able to watch trials. And we have the courtroom view networks and other things like that where you can actually watch the trial. Got court TV. You can, because it's hard for you to go during the day when there's a trial. It brings you into other ways to see the trial. But if I had to choose, I would say it's more important to watch what the jurors do and watch it all and then play it again. So you really get to see, how do these people interact with each other? How do you know how to start having instincts like Eric Oliver's, which are phenomenal?
Mm-hmm.
He wasn't born with it, he learned it. Not everybody's going to be phenomenal with it, but you can be really, really good at it. And that's the best path to it that I know.
Yeah. Other than focus groups, what's the value for lawyers in working with a top tier trial consultant?
This depends on the trial consultant. There are some trial consultants who are very gifted when it comes to knowing what to do during jury selection, by which I mean, what are we looking for? What are we trying to avoid? But 2, actually looking them in the courtroom and helping the lawyer make those decisions. When you've got people who specialize in that, that can be an enormous amount of help. So that's one area. That, in fact, was where jury consulting started. And there are people out there who are very, very good at it. It's one of Artemis's great gifts. But there's others, and I just mentioned her because she's my partner and I love her and she does great work, but and something Artemis is pushing right now and using is little teams will bring in somebody to do the jury selection, somebody else to do the day in the life video because they know how to tell the story on video. And so you really get a little group. Obviously, this requires a significant case. The second most important thing is strategy. Strategy means what are we trying to do to this jury and what is our plan to make them do that? How do we get, to me, strategy is the way you get jurors to think and decide the way we want them to. It's much, there's more to it than just how do we get them to like us and decide for us. In fact, I don't even care if they don't like us, if we've got them on the right path to wanting to decide for us. In a sense, Reptile is nothing but a strategy. Excuse me. So, jury selection, certainly, strategy. Consultants can be enormous help in helping you decide on the sequence of witnesses, on helping work with your witnesses. Some wonderful people out there. Josh was particularly gifted at it. There's others. Certainly in the last 5 or 10 years, the only witnesses I've wanted to work with, because there's other people better with some kinds of witnesses, but I want to work with the science witnesses. I want to work with the experts because they don't know and counsel doesn't know what you need to get from them. That will be the most persuasive. And that can be great help if you have somebody who can do that. And that requires that you have a good feel and understanding of science, et cetera, as well as the courtroom. And there are some people like that. There are some consultants who are really good. It's expensive. Do what I did with Gary Johnson and some others in those early years. I would sit there, I'd be at counsel table. Gary would say to the jury at the beginning, I got this fella here. He thinks he knows everything in the world. He's going to hand me a note. It's going to drive me nuts. But every so often he gives me a good note. So if you see an angry minute, don't worry about it. Or something that, so it would be comfortable that I was there. And there are some people very good at that. Where's the jury right now? What do you need to do? In that $250 million case, Gary came back. There was a cross-examination at the end of the case that wiped us out completely. And Gary got up and did the cross-exam of his life. And then there was a redirect, and Gary got up again to do a recross. And this was the end of a 6-week trial, 5 or 6 weeks. He was exhausted. He comes back and he says, was that enough? And I said, one more. You got to do the one more. He might not have. I don't think he would have if I hadn't been there. And if he hadn't done that, the guy would not have gotten to the point where we needed him, that it just released the jury and do the case our way. There are people who are really good at helping that way. If you're lucky, one of them works in your office. If you're really lucky, it's you, but you can't have during your working that objective thing. It's very hard to do. Trial consultants are like a jury-savvy partner in a case, co-counsel, who has nothing to do with the law or actually doing any of the pieces of the case or getting up and doing them. Think of them as Belichick or a Mike Krzyzewski or something like that. They're really good. You want to pick a trial consultant? The first question I ask them is, how many trials have you watched from beginning to end? There are some good people who haven't done that very much, but not very many of them. They'll be a lot better if they've watched a bunch of trials. The other thing to do is call the lawyers they work for. Nobody hires a trial consultant if it didn't help them the first time. Why would you put all that money and effort into it? Mm-hmm. And then see if the kind of help they offer is something you need. I mean, not every consultant is for every case or every lawyer. now that since the criminal book has come out, I'm working for a number of lawyers who've never heard of me or barely heard of me because they don't do civil cases, so they don't know about these. They know it exists, but that's it. So they'll say, well, what can you do for me? And I say, well, I can help you frame your case in this way. And I'll give them a very brief overview of the rule out method and show them why it works, etc. That's not me looking for work because I don't charge for most of those cases.
And I guess I'll just hold this up here. Trial Guides, we didn't publish this, the ABA did, but we've been selling it for some time, and it is actually selling quite well.
And
And it's
I need to mention that the only reason Trial Guides did not publish it is because Trial Guides doesn't publish criminal books. ABA is wonderful. They published it. They were a good publisher. It certainly is a good credential to have it from ABA. And since I'm trying to convince people to use a method that is new, it's good to have that imprimatur. But they certainly don't they can't. They publish too many books. They don't do the quality of care in the preparation and editing and production of the book. You guys have spoiled me, absolutely spoiled me.
thank you. That's our
I mean, what
editorial.
they do is okay, but you guys spoiled me.
Yeah, well, thank you. I appreciate that. Our editorial team is
Oh, you've
amazing.
got such a team there, such an amazing. If anybody's thinking of writing a book, write it. Send it to them.
Yeah.
Sorry, now you'll get a bunch of junk, but some of it will be very good.
No, it's great. We're always looking for innovative new things. I did want to step back to this because we haven't addressed it, but it was kind of a different take on your book way back, your tips and strategies for jury trials. But you did this one with Joshua Carton, who you've mentioned a number of times today, and I just wanted to give you the opportunity to sort of address, what was it that you two are doing in that book, and why is it helpful for lawyers?
Joshua is a very rare person in many ways. And I met him very early on in this business at an ATLA Ultimate or one of those things seminar. He is one of the most gifted teachers of anything, of anyone that I've known. He's extremely good at it. And he teaches stuff that is extremely valuable about communications. I mean, really valuable. It's the opposite of some of the garbage that people have been taught, and it's really good stuff. And he also writes really well, but he had never sat down. I'm thinking, we are all approaching our golden years insofar as they're going to be golden. And pretty soon we're going to be gone, and we do not want to miss what Joshua has to teach. And I'm afraid I inadvertently misled Joshua. I said, this won't be much work. I said, the plan is I will interview you, we'll transcribe the interviews. And for some reason, that just didn't work out, and he had to put enormous amounts of time into that book. Joshua was a mainstay for years of the Spence Ranch. One of the most unique, one of the things that made the ranch so unique, one of two or three things, was Joshua. He incredibly influenced the kind of advocacy they taught and how they learned it, and changed a lot of lives along the way. And again, it's just because of the brilliance of his teaching. And it's things most people would take home and think about and use and apply. Not techniques. I mean, you don't go to the Spence Ranch to learn how to conduct a cross-examination. You're going there to make yourself a good instrument. You do learn the other stuff as well, and Joshua was the pinnacle of that kind of work coming from there. And I thought, and I've been at him for years, write a damn book. And the only way
Yeah.
you get him to consider is, well, we'll co-write it. And that's really why I did that.
Yeah.
And he'll never forgive me. I mean, we're still close friends. but he'll never forgive me for the amount of work that it did take him. Because he's as meticulous with his writing as he ever is with everything else in his life. But what his stuff does, people like me will say, look, you need to be looking at the jury a lot. There's nothing persuasive about a view of you from that angle. You can't make eye contact with people unless you're comfortable making eye contact. And you can't just stare at one juror. That's not eye contact. You got 6 or 12. Joshua gets you to be able to do that stuff. Joshua gets you to talk from the heart. Joshua was an actor and a very gifted actor. And he was very gifted, as I saw in his classes. And the book, I think, is useful at this, of getting people to be able to, so that what they say is not hyper emotional, not drippy and gorpy, but just true. It's coming from a truth that I know. I can tell you, spend 2 days in the home with your client, you'll get to know them better, and you'll talk, and that's absolutely true. Joshua extends that sort of thing. So I thought this needs to be in a book. This really needs to be something that is in the actors, that's in the lawyers, in his working knowledge. That is part of who they are. It's good actors all have a few sources they go back to over and over again. I'm so happy that Backwards and Forwards is one of those. I think Joshua's work is along those lines, very much like that. And it's unique. There's one other, Catherine James and Alan Blumenthal, that used to do the same kind of work. They're retired now. There's some other folks who've taken over. And I don't know that they're doing the particular kind of work that Joshua's doing. I do know Joshua's doing it, and I know he does it brilliantly. He's one of the very few people I will suggest as a witness preparation person, because I sat there and watched him prepare a witness, and my God, I was ready to go on and be that witness by the time he was done.
And I did a 3-day session with him preparing a really exceptional experience.
Yes, and everything he does is an act of real personal importance to him. There's no such thing as phoning it in. Anyway, I just thought this is something that at least to introduce lawyers to, and then they can go on and expand from that with other people who might help them expand, or other books, or their own experience. Very, very useful stuff from him.
So we've gone through a number of different things, pertaining to all the work that we've done together and the work you did before. I'm going to ask you some questions now, just in regards to, your thoughts on certain topic areas. And the first one I have is, what do you think are the 5 most important factors in selecting a jury? And it doesn't need to be 5; it could be certainly less or more. But
Well, first you need to know why you're asking the question.
okay.
Not just because you think you're supposed to ask it. What are you going to do with the information they're going to give you? And that's one. How does that apply to something that will materially affect how a juror might listen to and react to and decide the case? You need to know. 2, don't lead the jury. Leave your questions as open as possible so they can tell you what's important about it. For example, who here has been in a car wreck? That's fine. The next question is, tell me about that. Not, was there a lawsuit or was somebody hurt? That leads them into something that might not be the most important thing to them. You might say, was anybody hurt? No, the most important thing was everybody blamed them. And you bury that right up by narrowing, tell me about that. Which leads me to the third thing. You don't get any decent information from a juror based on the first answer to a closed-ended question, like who's been in a car wreck, or who thinks this or who thinks that. It's the follow-up. And then you can use tell me about that as your follow-up for every single question. It's wide open. It lets them select what to talk about. If they don't get into a topic, part of it that you want, you can ask them. But let them at least a couple of times, if you've got time, tell me more about that, tell me more about that. You want to know how to ask your questions so that they lower the barrier to the bad answer. Do not try to win your damn case and open in voir dire. You can do a lot of things that will help you do that, but the goal is you need to find out the garbage that's in there that you need to get rid of. You won't, jurors don't poison each other. I don't say all my life I've been against capital punishment, but juror number 7 is for it, so now I think we'll be for it. The jurors are not flicks of brains like that. One juror is not going to, it's the old myth, but judges would automatically dismiss entire panels, which was, they just didn't know any better because they weren't going to affect them. And you wanted a fifth one, shut up, not you. Shut up and listen. The basic, what I call the ball rule of voir dire, 10% of the words spoken in voir dire can be yours. The rest must be the jurors. And if you're not doing that, you're doing something really wrong. So and number 6, there's 2 big sections in Damages 3 about voir dire. One is in the main text, one's in an appendix. Go read those. Then there are other really good, this is an important enough topic, there are other really good people out there who have done some really good work. Lisa Blue has got several books on voir dire that are really very helpful. The National Jury Project has a book that it's only about $900, but the law libraries have it. And if you go to the law library and tell them get the new edition, they will, called Jury Work, which I have to admit was the inspiration for the name of my company, which is Jury Watch. And there's a ton. You can't sit down and read the whole thing, but you can certainly look at it, as it applies to each case or piece by piece. And that, talk about Bibles, that is a great font of wisdom, and they keep it updated, including with the law and all the research and all that stuff. So it's know what you're doing. And there is one more thing that's very important, then I'll shut up about jury selection. Do it, practice it in front of strangers, people who don't know, who have nothing to do with the law. You can bring 4 or 5 to any place you want, can even be your office, and run the voir dire on them that you're going to do in trial the next day. Don't try to start voir dire unrehearsed. You want to be, you'll still be nervous, many people, but you'll be comfortable asking people those questions and getting their answers. And you'll begin to see, is this a good question? Do they understand it? And I need to, but it's like a dress rehearsal for an attorney. Attorneys are the only people in the world who don't do in front of audience live rehearsals before they go do the real thing. Athletes do it, and they have exhibition games. Actors certainly do it, dancers do it, orchestras do it. Everybody does it who has to get up and perform. And then lawyers wonder why they get up to do an opening or voir dire and they're so uncomfortable. Because you're scared, because you ain't done it, because you don't know what's going to happen. There's nothing wrong with being scared and having stage fright if it's minimal enough that it doesn't interfere with your performance. And so those are the things I would say are key. Other people might list other things. I mean, the most important thing is do it brilliantly, which ain't much help.
Um, this might be a challenging question. Early in my career, I think I mentioned I had watched the Jerry Spence videotapes on a variety of different topics, but I remember him mentioning, one of the jurors he would never want to leave on is a banker or somebody related to a banker, and I just wanted to ask you, are there any stereotypes in terms of professions or
Yeah, and I would not follow the banker advice now.
okay,
He's speaking of the old-fashioned banker for whom it was a profession, a career. Right now, most people working in banks are low-level employees who have no particular attachment to the job. This is just a way to make a living. They didn't grow up wanting to be bankers. Be careful. Demographics and stereotypes are extremely dangerous guides for voir dire.
okay,
Less time you have, the court's forcing it on you. But first of all, it's now illegal to do with a lot of things, such as minorities, but it's also dangerous. Take, for example, Jews. That would include me. He's a Jew, so he's probably going to decide such and such a thing. Or he's a teacher, or she's a nurse, or whatever it is. Your conclusion that she's probably going to do or he's probably going to do something is probably wrong. Among Jews, or teachers, or nurses, or Germans, or Irishmen, there is more variance among the people within any group than there is between any of those groups. You just can't do that. You can use it as a clue. This person is black and they live in Los Angeles. I have to probe now to find out if there are any feelings about cops that could affect the case as a prosecutor, I'd have to say. More important, if I'm limiting in time, now this might tell me who it's more important to ask about that. If I'm the prosecutor and I can't afford an anti-cop person, I need to spend time with that black juror that I might not spend with a white juror because the odds are that a black juror is going to be the one, or the Latino juror or whatever. So you can use stereotypes as guides to help you know where to probe. There are a few that I would consider in some cases to be useful. Engineers, for example, and other people who are trained in very analytic methods of problem solving, or whose decision making in their work is not based on more likely than not. You don't put up, I think it says in the book, nobody puts up a skyscraper on the more likely than not possibility it's going to stay up. But even then, times change, people change, and there are within that, it used to be get rid of the damn conservatives until we
Mhm.
found out they're our best damages jurors. Does that mean put a conservative on because they're a good damage? No, it gives you a clue. You don't get rid of them automatically because you found out they watch Fox News. Because that just doesn't tell you very much. So beware of the stereotypes. As I say, sometimes it's all you got. However, there's another huge, wonderful area that's opened up to us. Let's say you get your jury list as late as 9 o'clock in the morning and you have to start questioning those jurors at 9 o'clock. By the time you're done questioning those jurors for 15 minutes or a half hour, somebody at your office, usually it's a little team of people that you set up in advance, can have found out everything there is to find out about them online, social media. And most people have a lot of stuff that's out there if your people have the right tools to search for them with. So you can get a great deal of information about them. And that's never been true before. You can do it as long as you don't interact with the jurors online, but you can say, I don't think it's been outlawed any place. Certainly not the last time I looked carefully. And Artemis and I were working on a case in Florida a few years ago, and I was down there in the room during the jury selection, and she was at home working with a team of 4 or 5 people, and they were looking up all these people online. Well, I couldn't do that when I was sitting there in the courtroom. And this was a voir dire that was being run by a very experienced, really smart and capable attorney in a place where we had 2 weeks to do our jury selection. Might have been longer than it might have been longer than that. Artemis and her team found out more about those jurors online than we were learning in trial. By more, I mean more things that were important to our process of selecting or deselecting jurors. There are companies who'll do this for you. There's a place in Chapel Hill, I think their name is Jury X. There's others, I don't know if they're good or not. I generally tell people to get people, teenagers who need a few bucks, hire them. If you got a big enough office, get everybody in the office ready to go the minute that jury list is out. Place like Jury X, you send them the thing at 9 o'clock, they'll start getting you stuff by 9:15, 9:30, because they have a big team doing it. If you get a little more time or you want to do it, you can certainly do it. But the amount of information that's out there is huge. And some of it contradicts the stuff they tell you in court, which means you now might have a problem. You might have
Mhm.
somebody who's trying to lie to get onto the jury so they can call, their favorite call-in show and tell them how they screwed the plaintiff. Um, so that's another area of voir dire that don't ignore. Just be careful you don't do something the judge won't let you do.
Yeah.
And as long
Let
as there's no two-way thing involved, then I don't see there's any grounds a judge has to keep you from doing it.
yeah. Let me ask you this. A lot of people are faced with the possibility of very limited voir dire, say like a 15-minute voir dire. What is your best advice on that topic?
Stolen from Richard Jensen, a really good consultant in Austin, Texas. You get one juror. Well, first of all, as Artemis says, limit the number of questions. Don't try to cover 10 things. What are the two or three most important things you need to know about it? Your limit to 15 minutes, it is what it is. Now, what are you going to do? Well, I'm going to go to the most important things. Focus groups can help you find out what the one or two most important characteristics of jurors or their attitudes are. So that takes you down to a very few questions. Second, instead of bouncing from juror to juror, go to the jurors who are you're most likely to get for challenge for cause. From whatever information you have on or gather online or whatever, or you're just guessing. And once they start saying things that, if true, would mean they should go, stay with that juror. Don't say, I got to get to all the others. Stay with that juror. And when you're done with that juror, ideally, if you can get the juror removed for cause right then, that's fine. But even if not, you can still do this. You can then say, how many of the rest of you substantially agree with what Mr. Smith has just said? If the judge does not allow you to question the rest of those witnesses, regardless of time, he may be committing a very serious error, because you've now got evidence that those people might not be fit to serve, especially if the judge has granted that person a cause challenge. So once that cause challenge, other people agree with him, judge, you either got to get rid of those people or you've got to allow me the ability to question them. Make sure when you do this, two things. One, that you record, you have the court reporter record voir dire. A lot of them hate to do it, so they don't make them do it. And two, if you anticipate any part of an appeal having to do with voir dire, make sure you use all your strikes, because most appeal courts will not consider an appeal that has to do with something that happened in jury selection if you still had a preparatory challenge you could have used. But that's as I learned that the first part of that about who else agrees with this, which is a useful thing to ask anyway from Richard.
Um, Next question. Most common reasons for lawyers losing cases, and I don't know if that's generality is sufficient to provide a good answer, but if you had to think about the most common reasons why lawyers lose.
Well, personal injury cases is usually nestled away there in causation. You got a dynamite liability case. Causation almost always involves experts. Um, plaintiffs are seen, plaintiffs are seen to have motives to exaggerate. Take a look at Rick Friedman's polarizing the case to help with that sort of thing. There's other things to do too. But it's that causation thing. You don't need to know all the science. You need to know what science is, so that you and your expert can not just say, this is what we think and we're right. show the jury why the other side is using bad science. There's a chapter in the it's in Damages Evolving about how to do that. If you can show the jury that the defense causation doctor is not using legitimate science but trying to do something that will fool them, you don't have to say fool them, just try to, this is what they did wrong, so they'll figure out it's bogus. They'll figure out it's fraudulent. Now you've got two things on your side. One, the jury can quickly understand what's wrong with the defense doctor's testimony. And two, they'll now see the defense doctor is lying to them or is trying to fool them. You know, this try the lie notion that people have is all well and good, but nothing is as good as try the lie to the jury. You know, that's disrespectful of those jurors. You don't need to call it a lie. Just take a look at that chapter. It's a bit complex to follow, but that stuff works. Because that's one of the reasons people most likely are most likely to lose. Too much information. You've spent all this time collecting all this crap. And so you don't know what's important, what's not, so because you didn't do any focus groups. So now you're gonna give it all to the jury and expect them to be superhumans and extract your case from it. Too much information in one sentence is bad enough, much less in the whole trial. If you don't know Joe Fried's work, Trial Guides has a video of Joe teaching how to do a case briefly. I've been working on cases for forever. I don't know any case that should have gone longer than a week that needed to. Really, you just don't need that much stuff. And how do I know this? Because we test them all and come out the way we know who's going to, I say the focus groups are not predictive, but the jurors get the grasp on the whole thing in a couple of hours. I'm not saying do that, but learn what Joe is saying. I used to try to get people to do it. Nobody would believe me. Joe is obviously teaching it much better than I ever knew how to teach it. And he's absolutely right. So take a look at the Joe Fried. I think he spells it Fried, and it's on Trial Guides. He teaches a lot too. Learn what he has to say. Too much stuff loses cases. It's very hard to generalize beyond that. Being a crappy trial advocate, that is somebody who acts like the jury is beneath them, using legalese, that whole world of, one thing everybody can agree with about Jerry Spence is he was personable with the jury. He didn't kiss their asses. He wasn't overly friendly. He was personable. It's what Rick would say is the point of his book about Beyond Technique. It's who you are. But it's not the who you are you think that's going to be the useful one. There's a bunch of yous in there. And you want the one that will appeal to people. This is a day seminar by itself, this topic.
Yeah, yeah. I think Rick's point is you can't be an asshole in real life and come into the courtroom and think that you're going to appear as something else than that.
Yes, and you can, but it leaks through, and we know. And gimmicks can be fun, and once in a while they work, but don't rely on something just because somebody taught it to you. Master it, practice it, try it. Be wary of stuff you're taught by people who have not spent lots and lots of time in courtrooms, or you will be misled. Yeah.
Well, I just got a couple more questions. Really, I mean, I've got plenty more, but just because of the time, I'm going to cut down a few. And I wanted to ask you, I'd mentioned earlier on that the defense bar and the insurers and even the U.S. Chamber of Commerce continues to sort of rail on the size of the verdicts that have been coming out lately, and they attribute, I guess, some of that to Reptile and other things like that. But knowing what you know, what factors do you attribute the larger verdicts more recently in the past few years too.
We have many more lawyers operating at what would have been the absolute top level 15 years ago. There's a number of them who are operating on that top level. Some of the really superb ones are going to do well almost every time. But even among the rest of them who aren't that good, they're still up there now because they know so much stuff. That's part of it. Part of it is just given the world we live in, those large figures are no longer seeming like such outrageous things. In 20 years ago, a juror would say, $1 million, my God, that's the end of the world. That's a lot of money. But jurors now know what medical stuff costs. They hear on television all that this bill for $8 million, that bill for $800 million. Tesla lost such and such an amount of millions of dollars, hundreds of millions. Those figures are always running around. When you know how to get the jurors into a working group that wants to help your client, they will go to those bigger verdicts. Not automatically. You need to be good. The case needs to be adequate, et cetera, et cetera. I don't think it's because of any particular trick anybody's doing. I know Reptile's a big part of it. Even if you don't know the Reptile, the jurors are much more aware these days that this crap that they didn't think before, that they didn't relate to themselves, they're now relating it to themselves. Maybe that's bad. Maybe people have gotten more selfish.
What about negative feelings towards corporations? I mean, do you think that
That's as bad as it's always been. I mean, there were negative feelings about corporations forever. I think that split is still there. You know, business is business. It's a dog eat dog world. They got to do these things. You can't blame Ford for putting the gas tank in the wrong place and all that. So you really got to show that they did wrong. You got to know, that's a lesson I'm learning. I'm in the middle of doing something I've never done before, which is writing a habeas corpus affidavit for what's it called, ineffective counsel. You have to be very careful to just try to prove what you need to prove. You have to be very careful to make sure you're not creating or allowing any empty chairs. And if you are creating or allowing empty chairs because you can't help it, you need to know how to deal with them, because they can do you a lot of harm. That empty chair can become the compromise point among warring jurors. But I attribute those big verdicts to the fact that there are so many lawyers who are not just naturally gifted, but who technically know that technique, that know what they're doing. And now you add into that this new world that I call the trial of empathy. Don't please go out there and become a soppy, empathetic lawyer. That's not what that's about. It's about making empathy and humanness part of your world. And Nick's books are very helpful. Nick and Courtney's books are very helpful in that regard. There are others, like I say, Michael Leaserman, a lot of prick stuff. But that human thing that trial guides and others, but trial guides almost exclusively, has filtered out into the profession. So even if somebody hasn't read the book, they know about the stuff. That has an enormous effect on what jurors would be willing to do. One very simple thing that's very different. Lawyers used to be very polite, and as a result of being polite, they would not attack the defendant's conduct, not realizing that that's why the jury gives you money. It's not just because of damages. They can't stand what those people did. If you get them there, your verdict goes up. Is that hard to do with the town doctor who delivered everybody his babies? Yes. But it still can be done. It can certainly be done with almost everybody else.
And I mean, that really feeds into the focus on the defendant first in opening statement.
But even if you don't do that, and you got to be careful, because if it's not a punitive damages case and you've got a judge who thinks that you can't get into setting an example with this verdict, You still have to find ways to do it, just to touch that button, and then jurors will want to deter. Folks, it's up to you to decide, and you're going to make it sound like this is just about this case. It's up to you to decide how far someone can go in violating the safety rules of maintaining a safe floor where your kids go to school. How far somebody can go in violating those rules before they're forced to meet their full and fair responsibility. You just turned that into a deterrence case. But you didn't say that
Hmm.
because you're talking about this defendant, even though you're saying how far a defendant, gesture to them so that they can't accuse you of arguing deterrence, even though deterrence is half the reason we have compensation, etc. Um, know the drivers. There's a section in Damages Evolving called flashpoints, which are the things that we know create high empathy that creates damages, that drives damages. Nothing theoretical about that. So that disrespect, forced isolation, fear of the future. There's a number of things like that on that list and a little explanation. You'll find others. Lack of mobility is more important than pain in terms of the, I don't want to say more important, it's equally, it drives damages better than pain all by itself. If I have to have lack of mobility or pain, I would rather a case with lack of mobility, where somebody can't get up out of their bed, or they can't get up out of their wheelchair. Loss of, this is also from Damages Evolving, things like loss of freedom. This is a real big thing these days. Loss of freedom to choose to do what you want to do when you want to do it. So when you got the little old lady who picks a little old lady, little old man, I become a little old man. My car is only used to go to the supermarket. Nobody cares about the little old lady's petunias, for God's sake. What could be less relevant to my life? The little old lady's inability to grow her petunias is of no consequence. Her loss of freedom to be able to choose to go out and take care of her petunias, that's a big deal because it's about freedom. Working in duty as opposed to just violating the rules. Duty is a much, you got to be careful of that one because some judges are very stingy about what it constitutes a duty. So you have to know how to frame it. The book will help you with that. The law will help you with that. But you have a duty to follow the law. You don't have a duty not to speed, except that speeding is, it's against the law and you got a duty to follow the law. So you have to take it one step. There's other things like that that really drive damages solidly. Not if you have set up a situation by saying, starting with your client, an opening, in a case where you shouldn't do that, which is 90% of them. So the jurors are sitting there deciding your client did something wrong, even if you don't have a comparative issue, but still feeling, I wouldn't have done that. We can't reward her for, being in that position. She should have gotten a second opinion. Even though that juror has never gotten a second opinion in their lives, they wouldn't know how to get one. Learn the things that drive damages. Damages Evolving will help you enormously with that. It's one thing to teach them the law. It's one thing to teach them that those bad people did a bad, or those people did a bad thing. It's great to be able to show causation, all that other stuff. You need to drive the damages, especially on non-economic damages where the money can do no practical on paper good. It's not going to make the pain go away. It's not going to make mobile again. It's not going to do this. It's not going to do that. There are specific ways in that book, as well as a lot of other places, that will help you get jurors to want to fight for higher amounts of money.
You've mentioned a couple times today, you had desired to write a book on empathy and the effect in law, and you talked about that issue a bit today. Is there anything else, as you sit here today, that you think is important about that topic that hasn't been addressed yet?
About empathy.
Yeah.
Yes, I think what hasn't been taught, I would like to find ways that lawyers can learn to make them into people who have more empathy in situations where empathy has not really been. Yeah, oh, I feel so bad for my client. That's not empathy. That's sympathy, and it's a whole different kettle of fish. I would like to find a way to take people, especially maybe younger people, but anyone, that the ability, How to Win Friends and Influence People, that book I mentioned earlier, will help you do this. How to get you to be able to feel and understand the world from, say, the lying defense expert's point of view. That you automatically don't just say, oh, bad person, I got to impeach the hell out of this one. First, use the concept of empathy to understand, why is he doing this? Why is he saying this? Because once you know the why, you can start to get to that person. They'll have all the defenses of it, but now you can start to get to them. You might even show them to go along with you. F. Lee Bailey used to use a wonderful technique in criminal cases. This jailhouse stoolie would take the stand and lie about the defendant having confessed in the prison cell. Utter bullshit. But what he would do with the stoolie, rather than attacking him, is say, I bet it feels good to be out of jail today, isn't it? And, I mean, about 2 or 3 minutes of, I hope you enjoy your time here, and what did it feel like? And tell us and talk to me a little. Just what did it feel like when you first time, and how long you got to that knowing to ask those questions and how to ask them comes from his empathy for that guy. Doesn't mean he loves him or likes him. Doesn't even really feel sorry for him, but he understands on a feeling and logical basis what's in that guy. And then when he turned and used that on him, it was dynamite. So even if nothing else, but you're saying what you're saying, you've got a whole day to come out here and be on that side of that person that's so awful, right? Right. And that was devastating cross-examination. It was one of the reasons that Lee Bailey was so good. Because he had that, and he doesn't look like an empathetic person. There's nothing soft or sloppy about that kind of empathy. It is a practical working tool that happens to involve feeling as well as, logical things, rationale things.
Mhm.
Well, empathy for the juror's plight of having to make a hard decision. Empathy to realize that that person's going to have to go home and tell their friends they were just on a jury that decided a bunch of money. You might not have read about that in the damages book where it is, but you'd know it if you had empathy for the position that this piece has put these poor people in.
Mhm.
That's what I mean. And I'd like to find ways not just to teach its uses, but to teach how to do it. And I know how to do it. It's just a bear of a writing job. And frankly, the older I get, the harder it is becoming for me to really write. I'm getting so critical of my own writing that I'm spending much more time with it. And if I can let go of that, it took a year to write that the rule out. How many pages in that book? Is it
Yeah,
130, something like that?
it's probably it's 180.
Was it that long? Thin paper. Um, a year? A year?
Yeah, well,
I could write at one time 3 books in a year if I had to. But also I had to learn a whole lot of constitutional stuff to write the rule out method that I don't have to do for these other things. But still, it's a it's a harder process. On the other hand, I have more time to do it.
hmm
I'm not running around traveling the way trial consultants have to. You want me there, it's tough. I've
yeah.
seen the inside of my last airplane, I dearly hope.
Well, my last question, then we've got a couple questions from the audience, and I appreciate you hanging in there as long as you have with me.
Oh, this
Uh,
is fun. I'm talking about myself. How often do you get it? This is better than therapy, for God's sake.
Society obviously has changed quite a bit, particularly, post COVID, and as a parent, I'm hearing all kinds of things from teachers about the difficulty with reading and attention spans, which we already had some issues with before. But where do you see things going from here in terms of the ways that trial lawyers are going to need to deal with jurors that are potentially impacted by that type of thing, and social media and reality
I
TV?
don't I don't really buy the attention span thing.
Okay.
If you if what you are saying is important to their decision making, and you stop thinking that their time is free time, but it's something precious. If you use their time well, their attention span will be there. Look, your 8-year old can come home from a Harry Potter 2 hour, 2.5 hour movie and tell you the whole plot. They
Mhm.
paid attention the whole time. Why? Because they wanted to. The reason people have less patience with lawyers going on forever is one other reason I like Joe Fried's speedy trial method, is because there are so damn many things they could be doing instead.
Mhm.
It's not like it was years and years ago when there was nothing else. Oh, look, I'm either going to be here or standing behind the counter in the hardware store. And so politicians could make speeches that ran on half the day.
Yeah.
Abe Lincoln knew better, didn't he? Um, so I'm not worried about that. I'm very worried about education in general. It's not that I'm worried about reading, because people get an enormous amount of input online that replaces what they might have gotten from reading. It's just different kinds of information, different input. I worry much more about the gullibility of people, um, because they're not used to the careful kind of thinking that reading provided. Because when you read books, and that made you a more careful thinker. And most people, not everybody, that were just not, well, let's get a specific issue. Science is no longer in good repute. Um, Certainly for the half of the country that supports the current administration, all the top scientists get rid of them. You can't have those people because they have opinions that are counter to administration policy. Well, if I'm supporting that administration, I have to agree then that all those top level scientists are full of crap. So we've stopped believing in our scientists. Some of that, however, with good reason. There is a crisis of confidence that science has done to itself by
Yes.
failing to replicate, by failing to check its work. Science is selfish driven because it's mostly in the university, and the university scientists are driven by tenure and salary and rank. And those are strong drives that can affect their conclusions. So there's whatever it is, there is a science crisis. We can do something about that. As I mentioned earlier, there's ways to handle that. The biggest problem is we don't have any idea what the changes are going to be. Usually, sea changes happen once in a few decades. There was World War One,
Mhm.
then there was the Depression, there was World War Two. So over a period of what, from 1915 to 19, that's 30 years, and there were three major changes.
Yeah.
That's kind of rapid. We have three major changes now in a month, in a week, of things that are altering how we live, what we think the future holds. One of the things in Damages Evolving book, in fact, the reason we called it Damages Evolving was this very reason. It's not just enough to learn what are we supposed to do now, but how do we stay ahead as the world changes? And it's woven into the book about what to look for. Uh, What are people thinking? What are their values now? We want to appeal to jurors on their wavelength, on their values, not our own. What are their values that are given? That's where this lovely concept of freedom to choose, freedom to make the choice to go tend to her petunias when she wants. The hell with her petunias, that's not the important part. The important part is the freedom. Well, freedom, that came out of current events over the past 6 or 7 years, when suddenly individual freedoms became an issue. My kid goes to school and can't read To Kill a Mockingbird, for God's sake. Probably the greatest American novel, or certainly one of them. Can't read it because some people don't like it. That's a freedom issue. It's not, oh God, that's bad for education. Some people care about that. You don't have the freedom to choose to read it. That's very scary, and I hate that sort of thing. So you need to find the values that the jurors have in it, but things are going to change. Lawyers are going to need to be nimble. This is where the more you know about all those books behind you and all the other stuff that's out there and all the seminars, the more of that you know, the more nimble you will be. A blank slate is not nimble. A person who knows a ton of stuff and a ton of approaches is going to be able to deal with all that stuff. They'll have the chops to do it. It's like a great actor.
Hmm.
He may never have been trained to do a certain kind of role, but his training prepares him to do any kind of role. So I say the biggest thing in the future is going to be, things will change more in the next 5 years than they have in the last 50, according to some experts, and I believe that could be true. Things have now changed in this country. Substantive, everyday living things for most people have now changed more in the past 5 years than they did since the turn into this century. And maybe a lot more than that. And that changes people. We get one individual thing, people say, oh, what's 9/11 going to do? It really didn't do that much to what jurors were going to be like. Everybody's writing articles, oh, here's what the new juror will be after 9/11. Nonsense. It didn't happen. There were some things that happened, but not that really you'd pay a lot of attention to. But since then, things have happened on a very big, for example, you now need to be very careful to pick a jury that will not get into political arguments with each other. That used to be a good way to go, or it didn't make any difference. But you don't want a Trump and an anti-Trump person hating each other on a jury that has to be unanimous or 10 of 12. But who could have predicted that? So there's
Hmm.
no way to really say other than be nimble, stay alert, stay aware, and find out the people you know who are really good at this stuff. Not just trial people, but in general, who can take the tenor of what the nation is like, what the nation around you is like, what people around you. And you'll see in focus groups, if you do them well, you'll see these things emerge. Jurors won't even know that that's where but you'll see them. This is getting into a very sophisticated area. It's sort of like empathy. This is after everything, not after, but this is a much more sophisticated area about how the hell do you keep up? We're about to lose the great advantage of photographs and videos. I mean, a high school kid can now do a video that, they can change anything they want and it'll be believable.
Yeah.
Well, that's going to make a big difference in how people try cases. It already is.
Because you don't think that they'll trust the photographic or video evidence
They
necessarily.
better not. I mean, if somebody's motivated, they can make anything. They can take you sitting there now and put Donald Trump's voice into your mouth and have it come out of your mouth, or have you say things that you would never say about something. They can take a photograph. This has been true for a long time. You can have a photograph of a place to make it look safe or dangerous. Same place. All you do is change the angle and the lights, and you can go from looking, that's clear, wide open view, to, oh, I can see why this. So anything can change like that. We finally learned fingerprints are not infallible, that fingerprints are not unique to everybody. We're now learning how It's not that difficult to show a jury that there's reasonable doubt about virtually every DNA conclusion. That's not a change in jurors, it's a change in how we deal with it, but things are going to change rapidly.
Mhm.
Artificial intelligence, God knows what that's going to do to trials. Because jurors are going to use it. We know jurors go online right now. I mean, the judge will say, "Don't you dare go online," and they go to the bathroom in a recess, and you go in there. All the jurors are online on their phones looking things up.
Yeah.
Um, Now, artificial intelligence is going to tell them everything they ever wanted to know about the lawyer, about the case, and in almost no time. Before
Yeah.
they had to wait till they got home to do it. So I don't know what to say about the future. And I'm 82 years old. Um, so I only worry about a certain amount of the future. After that, you all are on your own. But the more you learn about your craft, which is the craft of getting people's minds to change the way you want them to make up, that's your craft. That's the goal of your craft. The more you specifically learn techniques of how to do that, and the more you learn to make yourself into the kind of person with the jury that's real and is all you, et cetera, et cetera. No different than for a good actor. Am I seeing a real human being up on that stage playing Hamlet or just somebody who learned a bunch of lines? The more nimble you will be to deal with whatever the changes are. I would not worry about that. It'll come what may. You will still be able to make the best of it. Unprepared, you better be lucky then.
Yeah. All right, I've got a couple audience questions. My friend Peter, I read The Right to Speak by Patsy Rodenberg and then Freeing the Natural Voice by Kristen Linklater and practice what they recommend. My question is, what additional books regarding voice do you recommend or any voice coaches or speech organizations to continue to
I
improve?
would, if the best advice I can give you, there's a very good book out there, and I wish I could remember the name of it, and I should know the author's name, and they're both skipping my mind right now. But a woman has written a book, two women, Lori Kohler in Oklahoma. So if you look up for books by her, one of them will be a book. It says, it's for women who are trial advocates. Well, it's for everybody. It's a really good book, and there's a good amount of stuff in there about voice. There is in the theater books, both theater tips, I believe, and in the book I wrote with Joshua, Theater for Trial, there's an exercise using Jabberwocky, the Lewis Carroll poem, that will help your voice tremendously. Do not use a singing teacher if you're going to find a coach. What you could do is you can go to a nearest university that has a decent theater department, which is a lot of them these days, or to a theater, a good sized theater, not an amateur theater, a place like the Guthrie or the Denver Theater Center or the Indiana Rep, places like that. If in New York, if you're in New York, there's a million of those places. Find out who their vocal coach is. Voice and speech are two different disciplines. Voice is where you learn about production of the sound, which is the important one. Speech is important as well, but ask them who that person is. Go to that person, because they don't make much money if they're a voice coach. Go to that person and say, I need you to design a program for me that you and I can work on until I learn how to do it on my own. That will help me with the work that I do, and here's the work that I do. And please call David Ball so he can talk with you about what it is that I need and what to try to avoid. Or Jesse Wilson would be very useful with that, as well as would Joshua Carton, to be able to answer that question. And again, I apologize to the people. I'm just the other
Well,
folks I'm leaving out, but those are the ones that come to mind right away. Um, Voice is extremely important. It's extremely important. That's why I have that vocal exercise in the Theater Tips book. That by itself will do you a world of good before you do anything else. It'll help both with speech, with articulation, but it will all, 'twas brilliant on the slithy toasted guy, and you learn to do this all the way through that poem while you're over enunciating. But really, maybe the gold standard there is finding a good coach and a good theater department or good theater, uh, who knows what you're trying to do. You're not trying to project to the balcony. You're not trying to sound formal. Linkletter, I'd be a little careful with, because that can end you up with something that sounds artificial if you're not very careful. Linkletter was very good, but I've seen a lot of people end up with an artificial Juilliard actor sort of thing, and you don't want to do that. Um, Improvisations in general can be fun and useful to do just to loosen people up, but not really for voice. That book that Laurie Kohler and
Well, I've got it, David. Actually, Jessica is amazing as always, and it's called Her Voice in Law, Vocal
that's right,
Power and
that's it.
Situational Command for the Female Attorney.
Yes, useful book.
And Jessica's actually put that in the chat link
Okay,
for.
good. It's not just for voice, and it's not just for her, um, which is true of most books like that. If they're good, they're really good for everybody. They just might vary it a little bit, one or the other. This doesn't. It's a good book.
All right, so the next question from Justin is there anything in the rule out method that applies to civil cases?
You know, I'm starting to find there is. In causation, and I'm not ready to use this yet, but it's the sort of thing. When the when they're throwing a bunch of possibilities of what caused someone's malady, rather than the doctor's negligence that destroyed the organ inside the body, you might want to say, they cannot rule out what we are talking about, but we can rule out what they are talking about. If you can do that. As I say, I'm not ready to use this, but I think there will be. Just be on the lookout for places that you're trying to clean the table. Rule out of your decision making anything that does not apply to, off the top of my head here. As of right now, would I advise civil lawyers to read the rule out book? Probably not, except I am a firm believer that civil lawyers need to start doing some pro bono criminal cases because the need is desperately major, and the rule out method makes it a very accessible thing for you to do. In most places, there is an insufficient number of government appointed attorneys, public defenders, and others who are paid for by the government. And there are just not enough of them. And too many people are ending up with people who should not be trying their cases, including some very major cases. So I would encourage everybody to think about, especially if you're not going to trial much, for God's sake. You know, God knows a lot of lawyers don't get to go to trial much. You want to keep up your skills. You want to stay comfortable in front of juries. Yeah, you're doing it for different purposes and the laws are different and all that stuff, but the rule out method makes it very easy. In that case, I would read rule out and then go down to the public defender's office or the clerk of court and say, look, if you need to appoint somebody, my schedule allow me to do it. I would love to help out. That's a big sacrifice. But there are an amazing number of criminal cases that are over in 2 or 3 days that you could fit in very nicely. God knows you will also volunteer for free at the Legal Aid Society and all that. But just to be a better plaintiff, civil plaintiff's lawyer, I don't think rule out will be a big help, except, and you could borrow the book for this, there is a very important addition. I'm glad Justin asked that question. There is a very important addition to the method called the jurors' rights questions that are in voir dire, that are covered in, I believe, in both Damages Evolving and in Damages 3. And those jurors' rights questions are where you get the jurors to follow the law. And that's covered in detail in the rule out book. It's how you get the jurors not only to want to follow the law themselves. In the damages, the rule out book, it's about how you get the jurors to want to decide on the basis of whether all the reasonable doubts were ruled out, and also how to make that juror fight the other jurors to do the same thing and not accept it if they don't. And that's a little, there's a good amount of that in the damages book, but that will take you a lot farther with it. So if you don't want to buy the whole book, you know what to do? Buy the book, read that section, and then give that book to your local criminal public defender's office. I use the profits on that book to get them books for free anyway, because those people have no money or very little money. So that would be the humane thing to do.
All right. Another question from Thomas. I know David has a paradigm for opening statements. Does he have one for closing arguments?
No, because I never did that because you've got much more freedom. However, the damages book, damages three particularly, and obviously all the damages stuff that's in damages of only, but there's a hefty section on closing in damages three. It just doesn't give you a specific structure to do it, because you're not dealing with the fact that it's all news to the jury. So I didn't feel that the structure is that crucial as long as you hit those points. In other
Yeah.
words, do you massage the instructions at the beginning of opening or the end of at the beginning of closing, the end of closing? When do you really deal with your undermining the opposition? Those things are less important. Where you deal with, say, undermining the opposition in opening is so crucial. If you do it first, you're going to lose the case. Or, I don't like to say that, but you're in real trouble because that's the first thing on jurors' minds. Don't tell them your warts until they've got your case. Then you can tell. I don't think that context is that important, or at least you've got much more variability there. So look at the things you need to put in it from whatever sources you use. And then that's up to the best strategist in your office and you, or whoever, to put it together in a way that is most persuasive and that's best going to handle the defense coming in between. Put the stuff that the defense can, here's my one piece of structure. Put the stuff that the defense can come up with a good answer to in your second opening. Sounds kind of obvious when it's
Yeah.
too late for them to get up again.
Right. I've got another a question I think that pertains to the rule out method. What advice do you have for people who also handle criminal cases? We may have already addressed that here at the end, but anything else for those that,
I would read rule out. I really would. I don't want to brag about this, but I don't know anybody else who has put in the research time of talking to people who've been on those juries, people who convicted, and all the. I don't know anybody else who's done that, and I don't know any other approach that is so easy to use if you use it all and you use it well,
Mhm.
um, and certainly nothing else that is as effective as it is. It's. Boy, I wish I could come up with stuff that foolproof for civil stuff. It really is and I'm not saying that because I did it. I did do it, but I had time to do it, and I had the background to do it. Lawyers don't have time to do it, and they didn't spend all that time anyway. Yeah, do that book.
Okay.
Uh,
Um, so here, Dominic asked a question that I actually cut from the end of my questions, and I'll pose my question first, and then add in Dominic's section. About 2 years ago, I heard a rumor around the trial guide's office that you were thinking about writing a book about charisma, and I understand that at some point that book got stopped, or you just decided that you weren't
it's
ready.
it was going to be a book about charisma and empathy.
Okay, got it. So Dominic's
Uh,
question is, how important is charisma in trial, and how does one improve their
that's
charisma?
what the book would have been about. There is a lot that can be said about it. Charisma simply means the quality that makes people feel good in following you. And that varies a lot. A baseball player or a football player can have charisma, and that's star power. We want to be what I used to work with a football player named Rocky Blyer, who was a Pittsburgh Steelers guy, one of the greats, and so he had star power, and he would sort of say, "Yeah, there's all these jock sniffers. You go into a restaurant to eat dinner, they all crowd around. They want a piece of you." Um, but there's also characteristics about a person that make us comfortable following them, and you can learn a lot of those. I'm trying to think if I've written about. I don't think I've written about it any place. I used to teach it in some seminars, but it's things like well, some simple things like knowing when to use eye contact and more importantly, when not to use it. It's like not being, not doing things like reading your opening, about using normal language. I mean, there's more to it than that, but it's those sorts of things that get rid of the barriers. And maybe it might be a good idea. We're doing a series with trial guides of interviewing consultants, doing a little consultants roundtable on each of a number of different topics. The first two are going to be on storytelling, and I think that happens right at the end of the summer. And then we're going to do one on some of the questions why do most people lose when they lose? And maybe a good one to do with a couple of people who know something about charisma, not necessarily who have charisma, but who understand the concept. Certainly Joshua, me, a couple of other people, just to do a round table on that. So maybe keep an eye out for that. And maybe an empathy one too, depending who we can get to do that sort of thing. Um, it's very hard to have empathy by imitating somebody who has to have charisma. By imitating someone with charisma, you'll come off looking like a jerk. I mean, everybody has their Jerry Spence imitations, but it's pathetic to watch somebody, trying to seriously imitate what Spence does, because it's not that sort of thing that creates the charisma. Um, And what charisma is for some people can be a huge turnoff for others. Think of some of the politicians in our world right now who got enormous empathy for some, enormous charisma for some people, and make everybody else, make the other people totally hostile. Same person. It has to do with their background, what we know about them, what they do. Um, is it about size, weight, strength? No. Ross Perot, who was a tiny little man, had charisma. Uh, Abe Lincoln, I'm told by the historians, had great charisma. He looked like a paralyzed frog half the time. Not your idea of look at the why are we comfortable? Why does Hannibal Lecter, the actor who played Hannibal Lecter, have such charisma? Should we run in screaming from him because of Hannibal Lecter? No, because he made it safe for us. Safe is the key word to watch somebody like Hannibal Lecter. He brought us into Hannibal Lecter's life and he didn't try to eat our brains. He made it safe. Safety is the key. Not telling people I'm here to make you safe, but behaviors that make people feel comfortable and safe in your presence and therefore comfortable and safe in following you. That's what I'm trying to get. And it's a brute to sit down and figure out how do I reduce this to paper. I can do it if I get the energy and the time, but I'm just not sure I can. Well, we'll see. We can certainly do one of those roundtables on it. Might even bring in people who are not involved in our business. Um, there's a couple of books out there on how to have charisma, and they're not bad. There's some decent hints. How to win friends and influence people is a good major step towards charisma.
I wanted to bring up, I guess maybe a counterpoint on that is that I've known a number of lawyers, and I can think of one in particular. I don't think he'd mind me sharing this story. Rick Friedman.
I was just going to say Rick Friedman.
is a guy who explained to me or described himself as as boring as watching paint drying during trial. And he's not a charismatic guy. His goal, I think, is to be, a caring teacher, to the jury. And you contrast that, of course, with somebody like Nick or Courtney, and there's many others, I suppose.
But charisma doesn't mean being like Nick and Courtney. Charisma can also be, think of the teachers you had who have charisma.
Hmm.
And when you do, you'll probably find out some of them were these quiet little mouse-like people who led you in their teaching to such wonderful places. That person now has charisma for you.
Right.
It's not about, there's not one kind of it. Ruth Bader Ginsburg, this squeak of a woman, um, by what she did, attained huge charisma for a lot of people. And I say squeak of a woman, intending no disrespect towards the departed justice, but there you are, she was a tiny one. Um, and a lot of the people who think they have charisma and go around charismaing are idiots. They don't
Yeah.
have charisma, they fart. I mean, that's it. That's the impression. So it's a very wide area of behaviors. If Rick says I have no charisma, then I'm boring, that doesn't mean he has no charisma. There's things he does, I've seen him, and can be doing that make people, being a good, caring teacher, coming from the right place, as per Beyond Technique book, can hold great charisma. Um, Children can have charisma. It's related to the word charm, it's related to the word magic, it's a religious thing, it's tied up in a whole bunch of different characteristics of humanity. But ultimately, it's somebody that I voluntarily wish to follow that person. I wish to be with that person. If I wouldn't be intimidated, I would love to have a beer with that person. Sometimes it's just that they're famous. Sometimes it's what they've done. Sometimes it's what they do. That's why I say that Rick can have enormous charisma for jurors once they understand what he's doing and why.
Hmm. I mean, I have to say that I have incredible respect for him, and I do really look up to him and appreciate him, not
Yeah,
just
no kidding.
not because of the verdicts, although I'm sure that in the profession, those that don't know him
Yeah, but
look
we all had respect for Rick before he started being at the top level of verdicts, didn't we?
right
A lot of
because of
respect.
who he was and is. So
Yeah. Yeah.
anyway, I'm going to move on. Last question from Mark, and this is back to the your theater background. What is the omission English teachers make at the beginning of Lear to cause us to miss the important part?
They think that they think the first scene of King Lear is about Lear deciding how to divide the kingdom. Whoever loves me most, I'll give you the biggest part. Now, Mr. English teacher, Miss English teacher, if you read the goddamn first 8 lines of the play carefully, you will see that Lear has already made up his mind how to divide the kingdom. Therefore, we must ask ourselves, what the hell is Lear doing in that first scene? And it's a whole different thing. And if you don't, Mark, if you don't, can't figure it out from looking at the script, send me an email. Trial Guys has my email. Well, it's Jury Watch. Anybody, by the way, has any questions they'd like to ask or talk about anything, Jury Watch, JURYWATCHW, Jury Watch at gmail.com. So, Mark, if you can't find that, let me know and I'll show you what I mean. Good question. A perceptive question.
Well, thank you, David, so much for your time. Any parting words, any thoughts that I haven't covered that you wanted to
My
cover?
my usual last little sign off thing is, God bless you all. We need you so badly today. I said this at the beginning, we need you because we are in a situation in our country where the people with the chutzpah and the ability to stand up for somebody with nothing, who has nothing, who is powerless in the face of this gigantic set of forces that's coming at us. I've always thought it was important, but by God, take you out of the mix right now, and we might as well just all move to the moon. You are much more important individually, not just all together, but individually, you are much more important than I think you have ever believed you are. And we need this so badly. My goal is, and I'm not the only one like this, is to try to help you be the best you can be. And that's a reptilian thing for me because it is self-protection. Because I want the world that I grew up in to be preserved. And it can't without what you do. 20 years ago, 30 years ago, it could. It can't do that anymore. Even if the current political situation goes away, AI is not going to go away. The corporations are not going to get smaller, et cetera, et cetera. We desperately need somebody to fight the little soft tissue injury, all the way up to everything else. That's why the people for me who have charisma, the people who can get up in front of a jury and do this work, that has charisma for me. I'll follow you. The more you know, the farther I'll follow you. Thank you for putting up with this for so long today. And Aaron, thank you so much. This has been very interesting for me. I never even thought about some of this stuff before. And Jessica, as always, thank you. Thank you so much for making this happen.